It is 9:05 a.m. on September 15th, 2021. Could I have counsel please put your appearance on record?
Taylor May on behalf of the Office of the State Attorney.
Tyler Brands on behalf of the Office of Public Defender.
All right, I'm having some technical issues, so give me a minute. Is this an interpreter case?
Interpretive case, Your Honor.
Yes.
Good morning, Your Honor. This is Laura Bretaña, Spanish interpreter. The interpreter has already been sworn.
Good morning. Thank you. If you could please connect to the headset.
Your Honor, I am connected, but apparently she's not hearing me. I'm gonna disconnect and dial again.
Or just use the overhead. So does that mean I need to hang up?
I'm still here, Your Honor. I'm sorry.
Okay, so do I need to disconnect?
No, we can do it in the overhead if you prefer. But I was connected to the podium and she wasn't responding.
All right, let's try this. Ma'am, please tell me your name.
Señora, por favor, dígame su nombre.
Mi nombre es Altagracia Tiburcio.
My name is Altagracia Tiburcio.
Okay, hold on one second.
Un momento, por favor.
Hmm. (21 6486). You're here charged with battery, domestic violence.
En caso del 21 6486 se le acusa de agresión física por violencia doméstica.
I'm going to appoint an attorney to represent you.
Se designa a un abogado para que la represente.
Sir, do you wish to testify here today?
Señor, ¿usted desea testificar aquí esta mañana?
I speak English, sir.
Yes, but we
Yes.
have to use the interpreter for her. So if you
Sí,
want to
pero-
testify, I need you to raise your right hand to be sworn.
Sí, pero el intérprete lo estamos utilizando para ella, así que si usted desea testificar, por favor, levante la mano derecha.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, do.
Juri promete que el testimonio que va a prestar será la verdad, solamente la verdad, nada más que la verdad. ¿Lo jura ante Dios? Sí.
Sir, I can't really hear you. I just need you to get closer to the microphone, and now the prosecutor might have some questions for you.
Okay.
Thank you.
Señor, no le puedo escuchar bien. Por favor, acérquese al micrófono y ahora la fiscal le hará algunas preguntas.
Good morning, sir. Can you please state your name for the record and spell your last name?
Buenos días, señor. Por favor, ¿podría usted decir su nombre para que conste en actas y deletrear su apellido?
Yeah, my name is Okan, O-K-A-N, and the last name is Kaplan, K-A-P-L-A-N. I repeat, last name is Kaplan, K-A-P-L-A-N.
Sí, mi nombre es O'Kane Kaplan, O-K-A-N-K-A-P-L-A-N.
Thank you. And what is your relationship to Miss Rosario?
She's my wife.
Gracias. Gracias, señor. ¿Y qué relación tiene usted con la señora Rosario? Ella es mi esposa.
Are you afraid of her?
Yes, ma'am.
¿Usted le teme?
Has anything like this ever happened before?
Yes, ma'am. Many
Algo
occasions.
algo como esto había ocurrido en el pasado. Sí, señora, en múltiples ocasiones.
Do you believe drugs or alcohol were involved in this incident?
No, no, ma'am.
¿Cree usted que las drogas o el alcohol tuvieron algo que ver en este incidente? No, no, señora.
And do you want to have contact with her while this case is pending?
Can you repeat that, please?
Do you want to have
Y usted-
I'm sorry, go ahead.
Y usted desea tener contacto con ella mientras el caso esté abierto, ¿podría por favor repetir la pregunta?
Do you want to have contact with her while this case is pending?
Yeah.
¿Desea usted tener contacto con ella mientras este caso está abierto? Sí.
That's all I have, Your Honor.
Son todas las preguntas que tengo, su señoría.
Any questions from the defense?
¿Alguna pregunta de parte de la defensa?
No, Your Honor.
No, su señoría.
She does otherwise qualify for PTR though, Your Honor.
I'm sorry, counsel, could you please repeat? Does she or
She does.
she doesn't?
She does otherwise qualify for PTR, Your Honor.
Su señoría, ella cumple con los requisitos para la libertad provisional.
All right, thank you. Thank you, sir, for coming today.
You're welcome, ma'am.
Muy bien, gracias. Gracias, señor, por venir aquí.
Sir, you can stay right there until I'm finished.
Thank you.
That way you can hear us.
Thank you.
Yes, sir.
Señor, usted puede permanecer ahí hasta que terminemos para que pueda escuchar. Gracias.
All right, ma'am. There is probable cause for your arrest.
Muy bien, señora, existen indicios de criminalidad para su arresto.
At this time, I'm going to place you on pretrial release and require that you post a monetary bond of $100.
En este momento se le coloca a usted en el programa de libertad provisional y se le requiere que preste una fianza de $100.
With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Las condiciones especiales son, se le prohíbe todo tipo de contacto con la víctima. ¿Entiende usted lo que significa todo tipo de contacto?
I'm asking you, ma'am.
Le estoy preguntando a usted, señora.
Perdón, sí.
I'm sorry, yes.
You can't possess a weapon of any kind, firearm or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. Is that the no contact form in front of her?
Yes.
Señora, se le prohíbe la tenencia de todo tipo de armas y armas de fuego y municiones. Se le prohíbe la convivencia. Se le permitirá regresar en una ocasión acompañado de las autoridades para recoger sus pertenencias. ¿Es acaso ese el formulario de la orden de prohibición de contacto el que ella tiene al frente? Sí, su señoría.
You can also possess no alcoholic beverages or consume them, and you'll be subject to random alcohol screens while on pretrial release.
Señora, a usted se le prohíbe la tenencia y el consumo de bebidas alcohólicas y estará sujeta a pruebas aleatorias de esta sustancia mientras se encuentre en el programa de libertad provisional.
Do you understand?
¿Eso lo entiende?
Sí,
Yes.
Did you have a question, ma'am?
sí,
¿Tiene alguna duda?
sí.
You can ask anything you want. I want to make sure you understand that everything you say is being recorded and can be used against you later. Do you understand that?
Usted puede preguntar lo que quiera, pero quiero que sepa que todo lo que usted diga se está grabando y podría ser utilizado en su contra en el futuro. ¿Eso lo entiende?
Sí.
Yes.
All right, what's your question?
Muy bien, ¿cuál es su pregunta?
Hablaron de alcohol. Yo nunca bebo. El alcohólico es él.
You mentioned alcohol and I never drink. He is the one that's an alcoholic.
All right, then it will be easy for you not to possess or consume any alcohol while you're on pretrial release.
Muy bien, entonces a usted se le hará fácil no tener ni consumir alcohol mientras se encuentre en el programa de libertad provisional.
All right, good luck, ma'am.
Buena suerte, señora.
Thank you, sir. Good luck.
Gracias, señor. Buena suerte.
We're going to try the headset one more time. Sir, please tell me your name.
Muy bajito.
He says he can hear me, but the volume is too low.
All right, let's try this one more time. Is this any better?
No.
No.
All right, just go ahead and take the headset off and we'll do it over the speaker.
Ya, ahora escucho.
I can hear now.
Okay, great. Sir, please tell me your name.
Rafael Bernardo Sosa.
Rafael Bernardo Sosa.
You're here in 20 CF 12646. A warrant was issued for your arrest out of Brevard County for violating your probation. There is no bond. We'll notify them that you're here so that they can come and get you. At this time, I'll appoint an attorney to represent you. Good luck, sir.
Okay.
Okay.
Sir, please tell me your name.
Jonathan Martinez.
Jonathan Martinez.
19 CF 15900. You're here for violating your probation. It looks like the allegation is you failed to pay and failed to attend and successfully complete the batterer's intervention program as directed. The bond on this is $2,500. I'll appoint an attorney to represent you. Good luck, sir.
Thank you.
Is that it for Spanish?
Yes, Your Honor.
That's all we have for the interpreter this morning. Thank you.
Thank you, Your Honor.
That ended. I'm ready.
Reynolds, you refuse court.
21 MM 6461. I'll find his refusal a willing waiver of his appearance today. There is probable cause here. I'll appoint an attorney to represent him. His bond is $1,000. He can't have any contact with the victim, no weapons, firearms, or ammunition. Maintain a separate residence. I'll allow a one-time return with law enforcement to gather his belongings. Please tell me your name.
State your name.
Randall Adlin.
I'm sorry, who?
Randall Adlin.
That's not the name I see, there's two names. So I had the other name. All right, this is 21 CF 12298. Sir, you're here because there's a hold on you from immigration. It looks like even if you post a bond, you won't be released because we have to hold you at this time for immigration. Good luck, sir. MM 6456. All right, so this was a reset from yesterday. Mr. Brands, do you want to reset it one more time or no?
Your Honor, State would just ask that you set a bond. This is a second mental health reset.
Yeah, so we'll waive the appearance, Your Honor. You can just set a bond.
All right, it's $500 on count one, $100 on count two, no return. And if the PD wasn't appointed, I will appoint you. Please tell me your name.
Andrea Sharber.
21 MM 6447. You're here charged with trespass on property after warning. Why was this reset?
She refused yesterday, Your Honor.
There is an open offer, though, Your Honor, of adjudication of guilt, credit time served, no return to Quality Inn, 1850 West Land Street. I'd have a chance to speak with Ms. Sharber and convey that offer as well as a plea form to review, and I believe Ms. Sharber wishes to resolve the case today.
All right, Ms. Sharber, raise your right hand, please.
You solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God.
Yes.
Thank you.
All right, you heard the state's offer. Are you interested in accepting that today? You can put your hand down.
What? I'm sorry, I didn't catch that.
Are you interested in accepting the state's offer today?
Yes, ma'am.
All right, you had a chance to speak with an attorney. You have the paper in front of you that explains the rights you'll be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes.
Do you have any questions for me about them?
No, ma'am.
You understand if you're on probation anywhere, this plea can violate it?
Yes.
You understand if you're not a U.S. citizen, you can be deported?
Yes.
All right, it looked like you have a question about the rights. You're pointing to the paper. Do you have a question for me or just for your attorney?
It was just for the attorney, Your Honor.
All right, I am appointing you in this case just because of that. I want to make sure that's clear.
I can't just speak to her as a friend of the court, so she doesn't have to.
You can, but I think because she had a question, I want to make sure.
Didn't catch what he told me, what he said. Just say that.
Oh, the PD was already appointed. All right, well,
In that case, I did speak to her as an attorney.
okay. She has a warrant out of Indiana? Is there a hold for that? Okay,
I think it's extradition only in the surrounding states, Your Honor.
okay. All right, ma'am. At this time, how do you wish to plead to the charge of trespass on property after warning?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 3 days you've been in custody. I have to order that you pay court costs. I'll give you a year to pay them. I'll also order that you're not allowed to return to,
The Quality Inn located at 1850 West Land Street Road.
you understand, ma'am? All right, good luck. You have 30 days to appeal in writing.
May I approach, Your Honor?
Yes, please. Thank you. Thank you so much. Sir, please tell me your name.
Brendan J. Potter.
21 CF 11873. You're here because a warrant was issued for your arrest, charging you with aggravated battery on a pregnant person, domestic violence. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Ma'am, did you wish to testify today?
Yes.
Please raise your right hand to be sworn.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Please state your name for the record.
My name is Kelly K. Stallings.
All right, I'm going to ask if the prosecutor has some questions.
Yes, Your Honor. Good morning, ma'am. What is your relationship to Mr. Potter?
He is my fiance.
Okay. Are you afraid of him?
No.
Would you be afraid of him if you were to be released from custody today?
No.
Has anything like this ever happened before?
No.
Are you willing to call 911 if anything like this or anything more severe ever occurred in the future?
We're actually doing family counseling right now, so we're trying to work out our problems at home.
Okay. But if something more severe happened and you felt threatened, would you feel comfortable calling 911?
Yes, but I'm not. It's not going to happen again.
Understood. Do you believe drugs or alcohol were involved in this incident?
I was under the influence at the time, and I stated things in the statement that out of anger.
Okay. And do you want to have contact with him while this case is pending?
Absolutely.
All right. Thank you. That's all I have, Your Honor.
All right, any questions from the defense?
No questions, Your Honor.
All right, thank you, ma'am.
Thank you.
You can stay there while I finish. Is he not out on bond?
Can
I believe he had an arrest on August the 15th for a battery by strangulation and some other DV charges. I'm not sure what's the disposition on the case if the state want to look that up, but it is the same victim.
I see that, but I don't, hold on, maybe I missed it. I don't have any paperwork saying he's out on bond.
I have a case, it looks like you picked it up on August 15th.
Right.
Bat strangulation, DV, bat DV, criminal mischief, and it was the same
Close.
victim. However, it was no information on 8/30 due to her being unwilling to prosecute.
All right, so there's no out on bond right now?
No, Your Honor.
Okay. Thank you. So he was released from DOC in January of this year?
Yes.
All right, I have 13 prior felonies, 14 prior misdemeanors. I only see one failure to appear back in 2001, but I see several probation violations. All right, sir. At this time, your bond is $15,000. You can have no contact with the victim. Do you understand what no contact means? You have to answer out loud.
Yes.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim. Do you understand?
Yes.
Are there any other conditions the state would request?
No, Your Honor.
All right, good luck, sir. Thank you, ma'am, for coming. Good luck.
Thank you.
Thank you. Please tell me your name. All right, you have several cases. A capias was issued for your arrest in 21 CF 4321 for failing to appear. The bond on that is none. I'll appoint an attorney to represent you. In 21 CF 12311, a warrant was issued for your arrest for battery, one prior battery, domestic violence. Another judge has already found probable cause in that case. I'll appoint an attorney to represent you. Your bond in that case will be $5,000. You can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon of any kind, firearm or ammunition. Were you living with that victim?
I don't even know who it is, ma'am.
Can the state tell us factual basis for that charge? Hold on one
Have a
second.
moment to confer, Your Honor.
Okay, yes, while she's looking. All right, Ms. May, go ahead with the factual basis.
The victim is Carmen Vargas. On or about September 11th, 2021, law enforcement was flagged down by Ms. Vargas at the Liberty gas station and stated that she was with her boyfriend, Mr. Royal Jr., and that they were in an intimate relationship when they got into a verbal altercation. Then he then slapped the right side of her face with his hand. All events occurred in Orange County, Florida.
All right, so that's the factual basis for that case. So you can have no contact with that victim. Do you understand that?
Yes, ma'am.
You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings. All right, and then in 21 CF 12362, you're charged with possession of MDMA and drug paraphernalia. There is probable cause. I'll appoint an attorney to represent you. Did I say what the bond was on the battery? No. It's $1,000. Sorry, that bond is $1,000. The MDMA is $1,000. The paraphernalia is $100. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. In 21 MO 1066, you're charged with open container of an alcoholic beverage. There's also probable cause for that. Your bond will be $100. Good luck, sir. And I'm appointing an attorney in all your cases.
And any action on the out on bond?
Oh. I'm going to revoke 21 CF 8215, but not the MO. All right, good luck, sir.
Your Honor, and just to be clear, I'm sorry, I was talking to that victim on the failure to appear case. It remained at 0.
Oh, yes.
Okay, thank you.
It's a capias. I can't change it. Please tell me your name.
William Smith, ma'am.
Thank you. This is 21 CF 12113. A warrant was issued for your arrest, charging you with aggravated stalking, dating violence, and obstructing justice. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Does the state wish to be heard?
Yes, Your Honor. Just a little background. State was going to file a pretrial detention motion on this. We decided not to at this time, and we might file one later. However, I'd still want to make the argument for a higher bond. First, he has this open case, the aggravated stalking, DV, and obstructing justice, which in that case, there are multiple victims, multiple threats made. Several independent witnesses. The threats include sending naked photographs to her family, burning down her apartment, killing the victim's son, burning down the victim's place of business, which includes childcare for multiple children, a threat that he would ruin her job, a threat that he was going to kill her granddaughter and her daughter as well. Then threats were made to an independent witness at the daycare, that he would kill all the employees of the daycare and that he would go to jail for a reason, being a direct quote. That witness testified that he called approximately 35 times before she even contacted law enforcement. So arguably that number is higher than 35 times. And then there was an independent witness also from the daycare, Ms. Diaz, who also mentioned threats that he would shoot Melissa and the employees of the daycare. So there's been several threats made to multiple different people with several different victims, including the two independent witnesses, the original victim, and arguably the children of that daycare also being in harm's way. He also has another open case that was recently filed on 9/10. We don't have a case number for it yet. That case happened before this case. The date of incident on that case was 8/12. We just filed a kidnapping, a burg with bat with intent, bat strangulation, and tampering. It is the same victim. That case was originally filed on. It came in as a non-arrest case, which is why it's not an out on bond case.
I was going to say, why is he out on bond on it?
It came in as a non-arrest, but we just filed it 9/10, but the date of incident was before this case. And then he also does have an out on bond from Osceola, a bat DV, date of incident also being before this case in June 27th. There is a no contact in place from that case. It is the same victim also in that case. I believe he posted a $500 bond in that case. So there's a lot of history with the same victim within the past 3-4 months, all violent history. I believe he also qualifies under PRR. He is a prison release reoffender. He was just released November 9th of 2020. I believe for doing drug charges as well as some other charges. I believe he received approximately 2 years with some credit time served in between of that. He also has out-of-state history. State's concerned about the likelihood to flee and his community ties. He does have a warrant, I believe, out of New Jersey. And law enforcement, when they spoke to the ASA about this case, said that the threatening calls that were made to the daycare were made out of county. They weren't made in Orange. I do not recall what he said, but he said it was either Broward or Brevard. So he's already left the county when he was making those threatening calls to the daycare for the case that we're here for today. So given an open case that should be coming through shortly, that is a PBL case, a kidnapping with intent, burg assault bat string and tampering with the same victim from August, then the bat DV from June, and in this case, the state contends that his behavior is escalating. The threats are becoming brazen, not only to the victim, but also to everyone that surrounds her life, is including more and more victims that have nothing to do with this, including the children and the employees at that daycare. And I do have a factual basis for both of those other cases, if Your Honor is interested.
The kidnapping?
Yes, Your Honor.
Yes, go ahead.
That case happened 8/12 of 21. The defendant went to the victim's house, had his nephew. He knocked on the door and asked to use the bathroom. When the victim opened the door, the defendant pushed the victim and entered inside and threw the victim on the bed and choked her until she could not breathe. The nephew then told the defendant to turn the TV up loud so no one could hear her screaming. The defendant also told the nephew to block the door to keep her from leaving. He then threatened to harm the victim as she reported the incident. The victim later escaped and ran to the sheriff's office. She was transported to the hospital, and law enforcement did observe injuries on her body consistent with her story. And then the out on bond Osceola case, 21 MM 1714, from June, the victim said they were arguing. He pushed her, pulled her hair, pushed her against a bed, causing a bruise to her right shoulder, kicked her in the right leg. When she tried to leave, he grabbed her by the hair and pulled her back inside. When he left the room, she was able to escape. He told her that he wants to kill her. She informed the state approximately a month ago that she does want to go forward with prosecution.
So the Osceola case is the same victim?
Yes, Your Honor.
And he was released on bond
A $500 bond in the Osceola case.
on what date?
That date of incident was 6/27, so I'm assuming 6/28, but I can double check that.
Because here are my concerns, Mr. Brands, and you've heard this from this court before. What reasonable conditions of bond can I place on your client with which he'll comply, given that in June of this year, he was ordered by another court not to have any contact with this victim? And in this affidavit, I don't know if you reviewed it before court, but there is much more than probable cause to believe that your client had extensive contact with this victim, which is in direct violation of a court's order. So I assume you're going to argue that the court should place some conditions and give your client bond. What are those conditions?
Your Honor, there are some conditions you can set that are typically included in an injunction. You can order a curfew for the defendant. You can require the defendant to relinquish any weapons. Any and all weapons, you can require the defendant to meet with either a pretrial release supervisor or some court supervisor to keep a schedule where they'll be and when. And this is done routinely with defendants on community control. Legally, you can't hold Mr. Smith at no bond, as these charges aren't some of the constitutional exceptions to pretrial release.
Actually, Counselor, the court can, if the court finds there are no reasonable conditions of bond with which your client will comply.
Yes. And you're referring to the statute 907.041.
Yes.
4C, which must be read with the Florida Rule of Criminal Procedure 3.132, which requires a pretrial detention motion from the state, which they have not filed.
That is incorrect.
It doesn't actually require that. The court can act independently of the state. In fact, we are independent of the state. Whether the state files a motion is up to the state, but what the court does is completely separate. So you are correct. The court has to balance your client's right to a bond, and this is not a punishable by life offense. So presumptively, he's entitled to a bond. However, if the court can't find any reasonable conditions of bond I can place on your client with which he'll comply that balance his right to bond with the responsibility to protect the citizenry of Orange County as well as this victim, I can detain him pretrial. I'm not inclined to, I'll just tell you, I'm not inclined to do that. But I'm still struggling to find reasonable bond conditions. Yes, obviously, this court will order him not to have any weapons. Presumably, he was ordered by the court in Osceola County for the same thing. And in the allegations here, he's not threatening to shoot, but to burn down the house. So I can order him not to have matches or lighters, but that's a creative way to get around the no weapons bond condition, right? So how do I protect this victim and the citizens of Orange County against your client? What are those conditions?
There was an allegation also of shooting, I believe, Your Honor, from one.
I think there was, but
witnesses. Yes.
absent that, also, I mean, if we're going to burn down an apartment, if that's the threat, do I order your client not to have matches, lighters?
I'm not familiar with every condition that you can set, Your Honor, but again, I must emphasize that if the state wishes to hold him here, they have to file a pretrial detention motion. And they have to include those facts in the motion to justify that, and without that, he is legally allowed, or he's entitled to reasonable bond under this charge. Again, I have a very short list of conditions that you can set. You can have him check in. You can have a curfew for him. You can say no weapons, but as far as the specificity that you would like to set, I'm
Your Honor,
drawing a blank here.
in regards to the proposed conditions that defense said about a curfew, no weapons, and meeting with a court supervisor, I don't think any of those would ensure his compliance. He's already been ordered no contact and has already not complied with a court order. Stacia's asking for a high bond on these two charges and for you to revoke his out on bond. He should be seen shortly on that kidnapping, burg with bat string, and tampering shortly as well, which he'll potentially also get other bond conditions on those cases. So Stacia just asked for any reasonable conditions that you can set on this warrant, ag stalking, and obstructing justice. Just ask for a high bond on those. Given his history with the victim, his potential likely to flee, his community ties, and the threats that were made, and to protect the victim in Orange County, and to revoke the out on bond.
All right, thank you. Mr. Smith, you keep raising your hand. You can say anything you want or ask any questions you have, but I want to make sure you understand everything you say is being recorded and can be used against you later. Do you understand that? Do you have a question or do you want to say something?
I want to say one thing, man.
Okay, then I'm going to have you raise your right hand to be sworn.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Please
All right.
state your name for the record.
William Smith.
Go ahead. Go ahead, sir. You can put your hand down.
Man, I don't even have the restraining order in Osceola or the charges. Every time this has been going on for 7 years. Every time she think I'm cheating on her, she puts charges on me and she drop them. Me and her went to virtual court in Osceola. They dropped the charges, and me and her moved back together. Then once I had sex with her daughter, that's when it got ugly, and she kicked me out, got me fired, and I went to Fort Lauderdale to stay away from her. That's why I went to Fort Lauderdale.
How old is her daughter?
26. And it was consensual and everything. And like, if you check my phone records, she's been contacting my family. She's been contacting me. She told me she didn't want to come to court today because she didn't want nothing to do with this. Like, the investigator just came and talked to me yesterday. I asked him to get my phone records from Broward, where she's admitting that she's doing all this because she think I'm cheating on her. Like, the lady was just with me last Thursday. I'm not looking for her. I work. She been coming to my hotel where I've been. And I left and went to Broward because she told me, oh, if you don't show me what room you're in, this is going to keep going on.
All right, thank you,
I
sir.
gave her the apartment. I don't want that apartment. I live in Poinciana.
All right, thank you. All right, so that did nothing to dissuade the court's concerns about his whereabouts because he just told the court he doesn't stay here in Orange County.
I don't.
Or the not having contact with the victim, because he just told me he's had extensive contact with the victim. So here's what we're going to do. On count 1, your bond is $150,000. On count 2, your bond is $25,000. You can have no contact with the victim at all. Do you understand what no contact means?
Yeah.
That means you can't talk to her on social media. You can't send a message through friends or family. You can't be within 500 feet of her residence or place of employment. Do you understand that?
Ma'am,
You can't call her place of employment.
call me.
This court doesn't have jurisdiction to order her to do anything. You understand, though, that you can't call her, send a text message, or a message through her coworkers, for example.
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. Are there any other conditions the state would request?
Not at this time, Your Honor, due to the 500 feet and the no contact.
All right, at this time, I'm revoking your bond in 21 MM 1714. All right, good luck, sir. Residence or place of employment. Please tell me your name.
Daquan Andre Bell.
21 MM 6460. You're here charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Does the state object to pretrial release?
No, Your Honor.
At this time, I'm going to place you on pretrial release and require that you post a monetary bond. However, I'll reduce that to $100. With special conditions, you can have no contact with the victim. You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. Do you understand?
Yes, ma'am.
Good luck, sir.
Thank you.
Dickens is medical.
Dickinson?
Dickinson.
All right, 21 MM 6487. Mr. Brandt, I'm going to appoint your office.
We'll waive the appearance, Your Honor.
All right, there is probable cause. Bond is $1,000. No contact with the victim or any witness in the case. No unsupervised contact with any minor child under the age of 18. No weapons, firearms, or ammunition. Maintain a separate residence. One-time return with law enforcement. Any other conditions the state would request?
No, Your Honor.
All right. Please tell me your name,
Jaro,
your whole name.
Jaro Fowler.
21 MM 6485. You're here charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Why doesn't she qualify for pretrial release? It just says no.
It says that she didn't provide an address. She only gave us a mailing address, but she wouldn't let the person who interviewed her know where she lives or where
All right.
she has been living.
All right, your bond is $500. You can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. Good luck.
Holland is medical.
21 MM 6479. Mr. Brandt, I'm going to appoint your office.
We'll waive the appearance, Your Honor.
All right, there is probable cause in this case. Bond is $500. No victim contact, no weapons, firearms, or ammunition. Maintain a separate residence. One-time return with law enforcement to gather belongings. Was there alcohol alleged in this one, Miss May?
Mr. Holland?
Miss Holland.
Miss Holland? No, Your Honor.
Okay, thank you. Please tell me your name. Ma'am, what's your name?
Harmony?
Just take a minute and breathe, okay? Listen, you're just here today. This morning, we're going to talk about probable cause and bond, okay? You need a minute?
My apologies. My name's Armani Jimenez.
Hold on, I can't really understand you, so just take a minute. It's okay, just take a minute and breathe. It's okay. Is your name Armani Jimenez? Okay. This is 21 MM 6480. Mr. Brandt, I'm going to appoint your office.
Yes, Your Honor, just a moment.
Yeah, I'm going to give you a minute to talk to your client.
Thank you, Your Honor.
All right, Ms. Jimenez, I reviewed the probable cause affidavit. There is probable cause in this case. Does the state object to pretrial release?
No, Your Honor.
All right. It's a I assume you read the facts. It's a family.
Her sister, I believe.
Yeah. All right, ma'am, I'm going to place you on pretrial release, which means you don't have to post a monetary bond today, but you do have to comply with the conditions of pretrial release. Do you understand?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You can't have any contact with the victim in this case, and you're going to have to maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings, but you're still going to have to live in a separate place. You understand? All right. I just want to encourage you to maintain contact with your attorney because there are lots of programs the state might be willing to offer you, or I don't know, they may even drop the charges. I don't know what the state's going to do, but it's a tough lesson to learn. You don't have to say anything, but now you're 18 and family squabbles that turn like this can end you here. So I just want to tell you to be careful and stay in contact with your attorney, okay? All right, good luck, ma'am. Do you have any questions? Okay, good luck.
Thank you.
Please tell me your name.
Kiara, why not?
21MM6463. You're here charged with battery domestic violence. I'm going to appoint an attorney to represent you. There is probable cause here. Does the state object to pretrial release?
Your Honor, state would ask for bond and PTR. The victim told law enforcement that this isn't the only time. He just never reported it. And given that he can't be here to testify, state would ask for bond with PTR. He also has a prior violent arrest.
Oh, I see that. All right, ma'am, I'm going to place you on pretrial release and require that you post a monetary bond. However, I'll reduce that to $100. With special conditions, you can have no contact with the victim. You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. Good luck, ma'am. Please tell me your name. 21MM209. You're here charged with battery. There is probable cause. I'll appoint an attorney to represent you. Does the state object to pretrial release?
Your Honor, same thing with this one. There just appears to be prior DV history, so state would ask for bond with PTR.
I'm going to place you on pretrial release and require that you post a monetary bond, but I'll reduce that to $100. With special conditions, you can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. You can't possess or consume any alcoholic beverages. You'll be subject to random alcohol screens. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings, but you can't live together. You understand? Yes, ma'am. All right, good luck, sir. Yes, sir.
Thank you.
Please tell me your name.
Pickenich.
21MM6484. You're here charged with battery domestic violence. There is probable cause, and I'll appoint an attorney to represent you. Does the state object to pretrial release?
No, Your Honor, state would just ask for a no return to Margaritaville.
Your Honor, as part of the pretrial release, would you be able to return to New Jersey? I think that's more of a administrative request.
Yeah, it's an administrative one. I don't care where she goes as long as she reports for court. All right, ma'am, I'm going to place you on pretrial release with special conditions. You can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. You can have no contact with a witness in this case. You You said Margaritaville, but isn't it Lowe's Royal Pacific? Did I hear that wrong?
I believe he was working at Margaritaville, and then they made contact with the victim later at his hotel because he left the scene.
Oh, okay.
But the actual incident, I believe, occurred in front of Margaritaville at City Walk. And she was detained by
I see.
Universal staff.
All right, you can't return to Margaritaville. I'm just going to say you can't go back to City Walk at all. You understand that? You have to answer out loud. You can't possess or consume any alcoholic beverages, and you'll be subject to random alcohol screens. All right, good luck. Thank you, Counselor. Please tell me your name.
Christine Schmidl.
21MM6483, you're here charged with battery, domestic violence. I'm going to appoint an attorney to represent you in this case. Give me one moment. There is probable cause. Your bond is $500. You can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. Good luck. Please tell me your name.
Laura Dean.
You have a warrant out of Lake County in 20 CF 2895. It looks like failing to appear on a charge of felony petty theft. There's no bond. We'll notify them that you're here so they can transport you, but I'll appoint an attorney to represent you in the meantime.
Thanks.
Good luck.
Francis is medical.
All right, I'm going to appoint your office, Mr. Brantz.
We'll waive the appearance, Your Honor.
This is 20 CF 594. It's a warrant out of Seminole. Hold on one second. This takes forever. All right, there's no bond. Please tell me your name.
Porfirio Gomez.
You have a warrant out of Osceola County in 21MM 573.
Are you asking?
No, I'm telling you.
Okay, correct, yes.
It's for failing to appear.
Yes, I had the third and it was the first. It was an honest mistake.
So I can't change it because it's a warrant out of another county, and it's probably a capias for failing to appear, so I can't make that change, but I'm going to appoint an attorney. Stay in touch with your attorney. They'll transport you down to Osceola, but you have a bond of $2,500, so if you're able to post it, you can post it and bond out. If not, they'll transport you back down there, but you have to present the defense down there to that judge.
Your Honor, is it 2,500
Able to
total?
bond out today?
No, Your Honor,
Hold on.
Gomez, he has a no bond.
Wait. Oh, I'm looking at the wrong one. Of course I am. Hold on. You don't have a bond. Let me find it. Oh, it is no bond. And it's not a capias, it's a warrant. Oh, no, it is a capias. So You're not able to post bond, but it is still out of Osceola County. We'll notify them and they can transport you, but you're not going to be able to bond out.
Are we appointing that case, Your Honor?
Yes. Good luck. Please tell me your name. 20 CF 2895, you have a warrant out of Lake County for failing to appear on a charge of felony petty theft. You have no bond. I'll appoint an attorney to represent you and we'll notify them that you're here so they can transport you. Good luck, sir. Please tell me your name.
Brian Hernandez.
All right, you have a warrant out of, it looks like Osceola, 20 CT 2470. For a DUI. Oh, the bond is $500. I don't know when that warrant was issued, so I can't take any action on the out on bond case because I don't know if it's actually an out on bond case. All right, we'll notify them that you're here, but you have a bond. If you're able to post it, you can bond out.
If I'm able to bond out, I'm able to post.
Yes.
Perfect.
Good luck, sir.
Thank you.
Please tell me your name.
David Lee.
You have a warrant out of Seminole County in, I don't know what this case number is. Zero 081091 CF. There's no bond. Failure to appear on a docket sounding of 2 counts of grand theft. We'll notify them you're here, and I'll appoint an attorney to represent you. Good luck, sir. Please tell me your name.
Michael Bailey.
20 CF 700. You're here for a violation of community control. Hold on. I gotta get out of this and go into another thing. Looks like it's for being arrested for the criminal offense of resisting without violence. That's all I have. There's no bond. I'll appoint an attorney to represent you. And it also shows that you're a sex offender. If that's accurate, you must maintain your sex offender reporting requirements. You understand?
Yeah, I was doing that today, or yesterday.
All right, good. Good luck, sir. Please tell me your name.
Joel Coro Guzman.
18 CF 9094. You're here for a violation of community control.
Yes, ma'am.
It looks like the allegation is you failed to remain confined at your approved residence as directed. Oh my goodness.
I went fishing.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. All right, so it looks like there are 13 charges of that. Same charge. There's no bond. I'll appoint an attorney to represent you. I think he's a violent felony offender of special concern as well.
He is, Your Honor.
All right, good luck, sir. Please tell me your name.
Leonard Lee Garcia Santiago.
All right, hold on one moment. Twenty-one MM 416. You're here for a charge of loitering and prowling. There is probable cause. I'll appoint an attorney to represent you. Your bond on that is $500. You can't return to the scene for any reason.
It's my friend's house. It's my neighbor. I don't know why they do that for. Because they wake up, they wake him up and my neighbor was there. I don't know why they put loaded on me.
So it sounds like you think you have some defenses. You want to talk to your attorney about raising those defenses?
I'm always there. It's my neighbor. I don't know why they do that like to me. I don't know why.
Well, right now you can't be there. That's what I'm ordering. So what you need to do is talk to your attorney about filing a motion in front of the trial judge to change that order. But until another judge says you can be there, you can't be. You understand?
Yeah.
Okay. And then
They put the
it looks like a violation of probation as well.
why?
Maybe this violated your probation. Does he have a VOP?
It was an on view, Your Honor.
They still got VOP.
Okay, because you're currently on probation as a violent felony offender of special concern. All right, I'll appoint the public defender's office in that case as well. You'll have no bond on that, so you want to stay in touch with your attorney so you know when your next court date is, and they can file a motion for bond in that. Good luck, sir. Sir, please tell me your name.
Mackenzie.
18 CF 17763. You're here for a violation of probation. I'm going to appoint an attorney to represent you.
No, I'm hiring a private attorney.
All right, then I will not appoint an attorney at this time. The allegations are that you failed to report as directed, failed to comply with all instructions, failed to make restitution payments, failed to pay court costs, failed to, it says you committed the new criminal offense of engaging in the business of a contractor without being registered or certified. At this time, there's no bond, so you want to get your attorney hired right away.
Is it possible that I can have a bond on this? I've been on for 2.5 years with no problem, and the charge is 1.5 years old that violated me, and I'm not like a flight risk or anything.
I'm not going to do that because the judge who signed the warrant, who's assigned to your case, said no bond at this time. So you need to file a motion in front of that judge.
Understand. How far out are the VOP hearings right now?
I don't even know that. I think it depends on the judge. But that's why I said you want to call your attorney right away. You said you're going to hire one. So I would do that right away so that you can get your attorney to try and get you in front of the judge as fast as possible.
Okay, so I don't get a VOP hearing today, like I won't have a court date today?
No, I can't give you one.
Okay. Thank you.
Good luck, sir. Please tell me your name.
Hector Santiago.
21 CF 12325. You're here charged with possession of methamphetamine. And it looks like that may have violated your probation. I'm going to appoint an attorney to represent you. There is probable cause. Is this also an on view?
Yes, Your Honor.
All right, because I don't see that. All right, sir, at this time, it looks like this is going to violate your felony probation, so you'll have no bond on that, but I'll appoint an attorney to represent you on that as well.
Okay.
Good luck,
Can I
sir.
get a court date?
I'm sorry?
Is there a court date?
I don't have that. I can't set that. It's not in front of me.
Your Honor, are you maintaining the $1,000 on the meth?
Oh, yes, I am. And you're not allowed to possess or consume any controlled substance or have contact with any known drug dealers.
So what do I do next?
Call your attorney right away.
Okay, so I have to stay in jail until,
Yes.
and he's gonna do the court date? He'll give me a court date?
Well, they'll tell you when it is. The judge assigned to your violation of probation and the judge assigned to your possession of methamphetamine, that's who you'll see for those charges. So they'll have to give you those court dates.
And I have no money to bond out those, but they'll just,
But you don't have any bond right now anyway on the VOP. So call your attorney right away.
This number?
Yes.
And I can use the phone in there?
Yes.
Tomorrow or today?
I don't, that's up to the jail. What's your name, sir?
Devontae Spooney.
20 CF 5014. You're here for violating probation. It's like you're on sex offender probation, and the allegation is you failed to comply with your mandatory curfew.
Yeah, it's 13 minutes late.
That counts. All right, at this time, there's no bond, and I'll appoint an attorney to represent you. And I show that he's a violent felony offender of special concern. Sir, when you are released, you must comply with your sex offender reporting requirements. You understand?
Yes.
All right.
Question.
Yes, sir.
I was at a funeral that day, which my probation officer knew about.
Mhm.
And she called me the next morning to, I guess, go over why was I late. I let her know about that as well. There wasn't a warrant issued then, so why was there one 3 weeks later issued out?
I don't know the answer to that. You'll have to talk to them about it. But if I were you, I would call the number on that piece of paper right away because that's the attorney they can tell you what attorney is going to be representing you. So if you have some defenses to the charge, you can raise them through your attorney.
Yeah, because I have the eulogy, all of that with me and everything.
I would definitely call your attorney.
Okay.
Yeah, good luck, sir. Yeah, we didn't. Yeah, I know. Thank you.
Thank you.
Is that all the defendants you have? What does that sound?
My pager.
You have anybody else, B? Because we still have people we didn't call.
I don't have any more paperwork, Your Honor.
Oh, they bonded out. It's French and Yandel. They bonded? Yeah. All right, is the state ready for 33 days?
Yes, Your Honor.
Go ahead.
Rebecca Griffith, 21 CF 8628, and information was filed yesterday. Here's a different order.
Very different. All right.
Your Honor, I did have Eric Nunez order moved up. Is that the first one you have?
That is the first one I have.
I think the state have thoughts on that one.
It was premature. The 33rd day is the 17th.
I would just have you hold that until Friday when we could do a hearing.
I'm just going to deny it, and then,
But we would have to file another motion, wouldn't we?
yes.
Could you just reset it until Friday so that we can just keep the motion that's in place now and then just have a new order for that date?
Well, it needs to be back on the ROR list so our ASA knows to respond to it.
Yeah, you're going to have to reset it.
That's my request, Your Honor.
But I mean, you have to do that.
Yes,
I
Your
don't,
Honor.
I don't know how you get all of that done.
I know we're able to file on the 30th day. I don't know if the order should show that they can be released on the 33rd day. Is that something you would
Yes.
grant?
Yeah, so if you read the rule, that's what it says, is you can file it on the 30th and say, if the state hasn't filed by the 33rd day, we're requesting that the court release him ROR or her, which we can do, but that's not what your orders say.
But we can predate it?
No, you don't predate it. The order would have to say that you filed this motion on this date, and if the state hasn't filed any charges, the defendant is to be released on this date by 5 PM. But that's not what the order says. It just says granted or denied.
Can we
So-
resend it to this afternoon? I can produce a new order to have that language in there.
The state's still not going to be put on notice, though. We're not going to get the email from your office. So the ASA is not going to respond.
Let's deny it, Judge.
We talked about this before, like, we have to change the process, and I'm okay with that. I'm okay if we change the process to follow the rule.
Yeah.
But that's not what your motion or your orders say. So as it is, I'm going to deny the motion, but if you want to go back and change it, absolutely do it. And you could set it for tomorrow.
Yes, Your Honor.
All right, so this is 21 CF 9615.
Yes, Your Honor, it's premature.
Okay, I'm gonna
33rd
deny
day is
it.
the 17th. Jester Ramos Perez, 21 CF 9123, notice of non-filing. Daquan Woods,
Thank you for noticing. Hard work, right? You look great. Oh. Wow. I feel like I should be on that program. Well, thank you. And of course, we're having this discussion just as I turn the record on, so. Thanks, Counselor. That's okay. All right, so it's 1:32, we're back on the record. If I can have counsel put your appearance on the record, and Ms. Sweet will do your case when they bring them in.
That's fine. I'm happy.
Taylor May on behalf of the Office of the State Attorney.
Tyler Brands on behalf of the Office of Public Defender.
Are we missing somebody already?
Anthony Johnson, he's mental health.
Where is he?
First move up, Your Honor.
I have Ronnie Thomas. Okay, Anthony Johnson.
Yes.
This is 21 MM 6472 battery. You said mental health?
Yes, mental health.
All right, Mr. Brands, I'm going to appoint your office to represent him.
We'll waive the appearance, Your Honor.
All right, the bond is $500, no victim contact, no weapons, firearms, or ammunition. Thank you. I thought I left it in here. Not return to the scene.
January. January 24th. I'm excited.
All right, there's that one.
There's a lot of them, for sure.
Sir, please tell me your name.
Just go ahead and state your name.
Oh, Ronnie Thomas.
All right, Mr. Thomas, you're here in 21 CF 12357, charged with possession of MDMA and drug paraphernalia. At this time, sir, I'm going to appoint an attorney to represent you. Counselor, there is probable cause. Sir, your bond is going to be $1,000 on count one, $100 on count two. You're not allowed to possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand?
Yes, ma'am.
All right.
Keep the bonds. Give me a cell. Let me go to sleep. I'm going to try.
She's been working really hard. Definitely.
All right, good luck, sir.
Ain't gonna need it.
Okay. We have Stanley Walker, mental health.
Wait,
You-
okay, you have who?
Walker, Stanley,
Mental health?
yes.
21 MM 6478. Mr. Brands, I'm going to appoint your office in this case.
We'll waive the appearance, Your Honor.
All right, did you see what it is? You don't want to,
It is,
No.
he is incompetent to proceed in other cases, so I would just have you take no action on his out-on-bond case instead of bond in his current charge.
all right. There is probable cause. His bond is $250 with a no return.
When was he found incompetent in the?
Right, and in what case? Surely not the misdemeanor for which he's out on bond.
I think that was the.
I see he's had an evaluation, however, I don't currently see an order.
In the misdemeanor case?
1 second, Your Honor. That's what I see in case management. I'm checking the clerk site.
I mean, I guess it could have been earlier,
Yeah.
much earlier this year.
Yes, Your Honor, that, I want to amend my statement. We have comp concerns. I don't know if he's been adjudicated incompetent.
Hold on, I couldn't hear any of that. Try one more time.
I would amend my statement. I believe we have comp concerns. I don't believe he's been adjudicated incompetent. But that would also be why we wouldn't plea him, even if we reset it.
Right.
So I would still have you just stay as bond.
All right, what says the state?
Your Honor, given that he hasn't actually been deemed incompetent and an order has not been signed, he's just been evaluated, it appears once. State would ask that you revoke and double, if not revoke and set at 0.
I'm looking at his history, counselor. His last conviction was in 2020 for a violation of a city ordinance. I don't see any violent history. And I have a note that says he has a 2020 case that was dismissed due to mental incapacity. Do you have that note?
For out of state?
Right.
Yes, Your Honor. The out on bond is also a trespass, but it's at the links. So it would track that there's potential comp issues.
But there's no allegations that it was violent, right?
The out on bond?
Or this immediate case, the instant case? I got to pull it back up, but I don't recall that.
No, Your Honor, the out on bond, he was just trespassed from the link station, refused to give his name. And in this original, the case that's before you today, he just kept reappearing at the UCF campus and hitting the emergency blue light button, using foul language. He picked up a wooden stick, stated he had the stick for the officers on scene.
All right, I'm going to take no action on his out on bond case. Thank you. Ma'am, please tell me your name.
Pamela Sears.
All right, you're here in 21 MM 353. A capias was issued for your arrest for failing to appear for a charge of retail petty theft.
Yes, that was right.
The bond authorized is $500.
Your Honor, the
What
state
happened
bid.
was I couldn't
Hold on, ma'am, before you say anything,
Okay.
let me make sure you understand that everything you say is being recorded and can be used against you later. Do you understand that?
Yes.
All right. If you're not entering a plea to this today, then you don't really need to tell me any defenses that you think you have. Because that, you'd want to tell the trial court, I can't change another judge's capias.
Okay.
So let me see, was there an offer?
Yeah, $50 bond. But I just want to go to court. I couldn't find the place. That's all. It was not
Right.
even an arrest. It was just petty theft without an arrest. So I just got up here. But that's all it was.
All right, let me ask the state if they
Yeah.
offered you something.
Your Honor, there was an offer conveyed of an adjudication, credit time served, no return to the Walmart located at 1700 South OBT, and cost of investigation to OPD in the amount of $93.
Did you have a chance to discuss that with her,
I would
counselor?
have concerns, Your Honor. I wouldn't like to enter a plea today on behalf of this client.
All right.
Ms. Sears.
So I am going to appoint your office in case you weren't previously appointed. So, Ms. Sears, I'm appointing an attorney to represent you.
Okay.
So he's going to give you a piece of paper that has a phone number on it. I need you to call that number as soon as you can
Yep.
to get in touch with the attorney who's going to be representing you.
Uh-huh.
And it looks like you might have 2 other cases. They're not in front of me today, but you want to talk to your...
No other case has been resolved. I have a court date for November 9th, 2021, and we're all set.
Okay, so make sure you
have
tell that...
clear. Call this number when I get upstairs.
Right, as soon as you can
Because
get to the
also
phone.
disappeared car. It was not an arrest, yes. It was under $25.
Okay, call that number as soon as you can.
Okay.
And ask your attorney to talk to you about all your
Okay,
cases.
and you have that November 9th, 2021, it's been already recognized?
I don't know anything about that case.
Okay, but you should have that.
But
There's no other case.
I don't have that information. What I'm saying is your
Okay,
attorney
but you
should be
heard
able to find it.
There is no other.
Okay.
I don't want somebody to come in using my name.
No, I don't think anyone's using your name that I know of. Good luck.
So are you taking no action, Your Honor?
No action. Yes, this is no action. Thank you. Yes. Definitely no action.
Next we have Jorge Frankie, behavior.
21 CF 12326. Mr. Brands, I'm going to appoint your office in this case.
We'll waive the appearance, Your Honor.
All right, there is probable cause.
When setting bond, state just asks that you take into account that it's arguably an attempted armed robbery. I understand it wasn't charged that way. However, that's how the facts read. And given his lengthy history, as well as out-of-state history, I believe he has 2 active warrants out of Georgia.
Yeah, I
One
saw
for
that.
false imprisonment, one for, I believe, disorderly conduct. And given the allegations in this case with a weapon, state would just have you take that into account when setting bond.
I'm sorry, I didn't hear the charge that you thought you might charge with. What was the charge?
Attempted armed robbery.
He does have quite a violent history. He does have several failures to appear. And warrants out of other states, which also concerns the court with guaranteeing his appearance at later court dates. All right, at this time, his bond will be $25,000. He can have no contact with the victim. He cannot possess a weapon, firearm, or ammunition. No return to the scene. No contact with any witness. Are there any other conditions the state would request?
No, Your Honor.
Okay. I did. Please tell me your name. 21 CF 12338. You're here charged with aggravated battery with a deadly weapon. I'm going to appoint an attorney to represent you in this case. One moment while I pull it up. All right, there is probable cause here. She has no criminal history. Why doesn't this qualify for pretrial release?
She was never interviewed. So you can't just automatically qualify.
Oh. Okay. All right, ma'am, at this time, your bond is $5,000. You can have no contact with the victim. You can't possess a weapon of any kind, firearm, or ammunition. You can't return to the Walgreens located at 11018 International Drive. Do you understand?
Yes, ma'am.
All right, good luck, ma'am.
I have a question.
Yes, ma'am.
Can I see a doctor because the law enforcement last night, I can't really move my hand. I'm not gonna be able to afford the bond. So I'm requesting if I can try to get an x-ray on my hand where the correctional officers hurt me last night while I was in the cell.
So I don't know if I have jurisdiction to order them to x-ray your hand, but I'm going to ask, can we have her sent to medical? Is that possible?
Yes, ma'am.
All right, so I'm gonna have you sent to medical, ma'am.
Thank you.
Good luck.
I have another court date.
I can't give that to you at this time. I don't know what your next court date is. It'll be in front of a different judge.
Okay.
All right, good luck. Please tell me your name.
Guillermo Hewitt.
All right, one moment. Let me pull your case up. You're here in 21 CF 12354. It almost seemed like it was going to be sequential.
Almost.
You're here charged with attempted first-degree murder with a firearm, aggravated battery, great bodily harm with a firearm, shooting or throwing into an occupied vehicle, and shooting from a vehicle. At this time, I'm going to appoint an attorney to represent you, sir. Did the state wish to be heard?
Yes, Your Honor. As to count one, the attempted first-degree murder with a firearm, that is a life offense. State is requesting that you hold him no bond pending an Arthur hearing downtown, and is requesting that you set reasonable bond as to count 2 and the F1, count 3, the F2, and count 4, the other F2.
All right. Mr. Brantz, any response from the defense?
No argument, Your Honor. He is entitled to a full Arthur hearing to set bond with his attorney.
He is. All right, sir, at this time, you will be held with no bond on count 1 because it's a first-degree felony punishable by life. On count 2, your bond is $50,000. On count 3, your bond is $15,000, and on count 4, your bond is $15,000. You can have no contact with any victim or witness in this case. Do you understand what no contact means? You can't possess a weapon of any kind, firearm or ammunition. Hold on one second. Are there any other conditions the state would request?
Your Honor, state would request a no return to the Dollar General warehouse located at 6375 Emperor Drive.
I will order you cannot return there. Do you know where that is? You have to answer out loud.
Yes, ma'am.
All right, you can't return there. Good luck, sir. Please tell me your name.
Juan Rodriguez.
21 CF 12358. You're here charged with battery of an emergency medical care provider and disorderly intoxication. I'm going to appoint an attorney to represent you. Mr. Morans, did you wish to be heard?
Not at this time. I just wanted a moment to confer with our client.
All right, I'll give you a moment. We're not there. He's not Spanish.
No, I'm just letting you know.
Oh. Thank you. Thank you. No, I appreciate it. Is that next or no? Okay. All right, sir. At this time, I'll advise you there is probable cause here. Your bond is $5,000 on count 1, $100 on count 2. You can't have contact with any victim or witness in this case. You can't possess a weapon of any kind, firearm or ammunition. You can't possess or consume any alcoholic beverages or any controlled substance without a valid prescription. Do you understand?
Yes.
And what's this, hospital? You can't return to Dr. Phillips Hospital unless you have a doctor's appointment or it's a medical emergency. So hear what I'm saying. If you have a medical emergency, go to the ER. I'm not telling you not to.
Right.
But unless it's that, or you have a doctor's appointment, don't go to the hospital, okay?
I understand.
All right, good. All right, good luck, sir. Thank you. Please tell me your name.
Jose Merced Jr.
Wait, what's your last name?
Merced Jr. Merced Sayas is what you got on record.
That's what I have. Thank you, yes. Sir, you're here in 21 CF 12360, charged with possession of cocaine and drug paraphernalia. I'm going to appoint an attorney to represent you at this time. Let me pull up your case. Give me one moment. Sir, there is probable cause here for your arrest. Your bond is $1,000 on count one, $100 on count two. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. You also can't have contact with the co-defendant in this case. Do you understand?
Yes.
All right, good luck, sir.
Hillman Rock is medical.
Oh, thank you. 21 CT 4435. Mr. Branch, your office already represents him.
We'll waive the appearance and enter a plea of not guilty, Your Honor.
Division 63, pretrial conference, October 5th at 1 o'clock, courtroom 12B.
Billy Robinson, medical.
21 MM 5791. Your office also represents him, counselor.
We'll waive the appearance and enter a plea of not guilty.
Division 62, pretrial conference, October 18th at 9 o'clock, courtroom 9B.
Thomas Brandon, medical.
20 MM 331. Mr. Branch, your office already represents him as well.
We'll waive the appearance and enter a plea of not guilty, Your Honor.
Oh, it's a VOP.
Oh, we'll enter a denial, I'm sorry.
Thank you.
VOP status, October 25th at 8:30, courtroom 4B.
Thank you, Ms. Sweet, for your patience.
Oh, no problem.
Go ahead and put your appearance on record, please.
They didn't, when
I
they,
know who you are.
they're gonna call the case?
I will. All right, who are you here representing?
Mr. Leslie Lewis.
Yes, let me pull it up. It just takes me a minute now. '21 CF 12339.
Leslie Sweet on behalf of Mr. Lewis.
All right, Mr. Lewis, you're here charged with possession of cannabis with intent to sell or deliver and possession of cannabis greater than 20 grams. Ms. Sweet, did you wish to be heard on probable cause?
I would concede based upon his admissions that there's probable cause. I'm just asking the
I agree.
court to set a bond on the, because the bond is already gone on the first case. I can't say what that drug is. Ms. May, what is it called?
The out on bond, Your Honor, we ended up filing Utilone.
Oh, Utilone?
Utilone.
So there's only one charge on that out on bond case, just Utilone.
Oh, I see. So, okay, hold on. Let me say, I agree. There is probable cause in this case. So let me set bond on this one. I'm going to stay the bond at $1,000 on count one, $100 on count two. With special conditions, you can have no contact with any known drug dealers. You can't possess or consume any controlled substance without a valid prescription. Do you understand? And then, Ms. Sweet, you're asking the court not to revoke his out on bond?
It looks like it was discharged. I went and looked in the system a few minutes ago. So you probably just have to reset it. It's at $2,000 right now.
Your Honor, he failed to appear at.
Yeah, that was me. I did that. I fixed it.
At arraignment, there was a motion to quash that capias about a week later, I believe.
Yeah, I did it. It was my.
The judge set it aside, so the capias was recalled on April 19th.
Okay.
So the capias has been recalled as of April, and I don't believe it's gone to any other court date since then.
He has not had another court date?
No.
No, Your
Okay.
Honor.
But you believe the bond has been discharged?
This, I looked a few minutes ago and it said that the $2,000 bond was discharged. If you just reset it back, it'll come back again.
All right, what says the state?
Your Honor, I'll leave it within your discretion. He was out on bond for a drug offense. He picked up a new drug offense. And he had children in the car, so I'll leave it within your discretion.
He did, and Counselor, he has a fairly lengthy history of drug convictions.
The only thing is that he has the card.
Oh, for cannabis, for marijuana?
Yes, and the bags were packaged where he picked it up from the dispensary. So that's going to be another issue that we need to deal with. But
I see.
I represent him. He's not going anywhere.
Okay, give me 1 second. Let me look at this one more time.
Your Honor, he had over 100 grams of cannabis, unused plastic sandwich bags, and a single black scale. Usually when things come from the dispensary, they're labeled with the name and what it is in the dispensary and prescription information. I don't believe we have that in this case per the affidavit. It just says there's 2 sealed market bags, RS-11 and dough, and then 2 rolled tobacco cigars in the armrest. And then in a large black backpack on the back seat with the children was a large clear plastic bag containing over 100 grams of cannabis. So
Yeah, with the
arguably, it was
children.
not packaged the way it would come from a dispensary.
Right here.
And it says his license
Black backpack.
was invalid and expired
Yes.
card.
His medical marijuana.
The medical
card
marijuana
is-
card, it says it was invalid and expired.
Expired. He said that he just bought something from the dispensary.
Hmm.
And he has, it's reinstated, he said he paid the money, the $75 and everything. He wouldn't have been able to buy the stuff if the card was.
All right, here's what I'm going to do. I'm actually going to change the bond in the instant case. And I'll not hold him at no bond, Ms. Sweet, per your arguments. But I'm going to raise the bond in the instant case. So your bond on count 1 will now be 5,000. Count 2, I'll stay at 100. And as for your out on bond case, I'll revoke and set it at 2,000 on the one count that the state filed. So I'm not going to hold you at no bond, but all the same conditions apply. So you can't have contact with any known drug dealers, you can't possess or consume any controlled substance without a valid prescription. All right. Anything else, Counselor?
No, thank you very much.
Thank you, ma'am. Have a nice day. Good luck, sir.
I'm gonna come back here. This is my bag. Miss May, take care.
Thank you, you too.
I'll probably be back tomorrow.
Okay.
And Ms. Sweet, thanks for coming in today, but you do know you can do it electronically, right? I've had you virtually, right?
But the thing is that I needed to get to the police report, because last time I did, I didn't know anything about the case.
I got it. All right, I just want to make sure you knew that option was available.
Seeing people.
I know it is nice. I'm glad you came. I don't want to discourage you from coming, but have a nice day. This is Judge Gibson. Do I have an interpreter on the line?
Your Honor, can you hear the interpreter?
Oh, now I can.
This is Laura Royo, State Certified Interpreter, previously sworn.
All right, if you could please connect with the headset.
Sí, sí, la escucho.
Connection is established.
Thank you. Sir, please tell me your name.
Omar Moreno López.
Omar Moreno Lopez.
2016 CT 2432. Sir, you're here for a habeas that was issued for your arrest for failing to appear on a violation of probation on a charge of operating a motor vehicle without a valid driver's license. There's no bond authorized on that habeas.
Your Honor,
Yes.
was that a violation of probation or no valid driver's license?
The failure to appear on the bond.
So he had a violation of probation, and then apparently whatever that hearing was, he failed to appear. So a habeas was issued for his arrest. I'm going to appoint an attorney to represent you. There's no bond authorized on that habeas. Good luck, sir. Is that it for interpreter cases?
Yes, Your Honor.
Thank you, that's all we need from the interpreter.
You're welcome, Your Honor. The interpreter will.
Have a nice day.
Too.
That's unusual.
Asanya Anthony, mental health.
Thank you. 21 MM6457. Mr. Brands, I'm going to appoint your office.
We'll waive the appearance, Your Honor.
I'm going to set the bond at $500 with a no return and revoke the out on bond case. Please tell me your name.
Yancey Fillmore.
Good afternoon, sir. You're here in 21 MM 6482, charged with trespass on property after warning. Was there an offer?
Yes, Your Honor, the offer the state conveyed was an adjudication, credit time served, and no return to the McDonald's located at 3005 West Colonial Drive.
I did have a chance, Your Honor, to speak with Mr. Fillmore and convey that offer as well as a plea form to review, and I believe he wishes to resolve the case today.
All right, raise your right hand, sir.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, ma'am.
Thank you.
All right, sir. You had a chance to speak with an attorney about the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes, ma'am.
Do you have any questions for me about them?
No, ma'am.
Did you have a chance to review that piece of paper in front of you that explains those rights to you?
Yes, ma'am.
All right, after reviewing that, do you have any questions about it?
No, ma'am.
You understand if you're on probation anywhere, this plea can violate it.
Yes, ma'am, I understand.
And if you're not a U.S. citizen, you can be deported?
Yes, ma'am.
All right, sir, at this time, how do you wish to plead a trespass on property after warning?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 2 days that you've been in custody. I have to order that you pay court costs. I'm going to make that a lien. I'm going to reduce it to a lien. All right, good luck, sir. You have 30 days to appeal in writing.
Your Honor, is there also no return?
Oh, and you're not allowed to return to that McDonald's.
Understood. Yes, ma'am.
All right. And, sir, I just want you to, I read the affidavit, and it says in there that you knew you weren't supposed to be there, but you went because it was convenient. So you can't do that again. You know that.
Yes, ma'am, I understand.
I'm sorry. I understand it's convenient, but you got to find another place.
Yes, ma'am.
All right. Good luck.
All right, thank you.
Yes, please. He said he knew he couldn't be there. So I just want to tell him, don't go back. Thank you. Sir, please tell me your name.
Gordon?
All right, Mr. Gordon, you're here in 21 MM 6477, charged with trespass in structure or conveyance. Was there an offer?
No, Your Honor.
Okay. All right, sir, your bond in this case is going to be I'll leave it at $250. You can't have any contact with the victim in this case. And I show that he's out on bond.
Your Honor, as the current charge is lesser charged offense as well as nonviolent and not drug related, I would just have you revoke and double.
Your Honor, state would ask that you revoke that out on bond case. He's been out approximately a month and a half. It is a cocaine with intent to sell and deliver, possession of MDMA, and possession of a controlled substance with intent to sell, so arguably all F2s. So it is rather serious, and the reason state did not convey an offer to date is because arguably this case that he's out on bond for is a grand theft motor vehicle.
No, not the out on bond case. You mean the new law?
It's new law. I'm sorry, yes, Your Honor.
Right.
That's why an offer was not conveyed to date. So it may be filed as trespass or it may be filed as that grand theft motor vehicle. However, given that he was out on bond for F2s and picked up a new law offense, state would ask that you revoke.
Again, Your Honor, the part of the bond conditions are to not use drugs and alcohol, and up to this point, even with this current charge of trespassing, we don't have any evidence of his drug use, so I believe he is participating in the judicial process.
There's a notice of non-filing on 9/2. That's why he was released, so he's out on ROR for those drug offenses. So he was released 9/2, and he picked up this new offense within 2 weeks.
I was never out on bond.
All right, based on the facts that I'm reading in the affidavit, his criminal history, and the out on bond, I'm going to revoke it at this time, counsel. You're going to have to file a motion in front of the trial judge. All right, good luck, sir. Please tell me your name.
Stephen Morcad.
21 MM 6475. You're here charged with petty theft. I'm going to appoint an attorney to represent you. There is probable cause.
I was given a lawyer today. Right here.
I'm sorry?
Right here.
He was asking if he's going to get a lawyer appointed to him, Your Honor.
Oh, yes.
I was given a lawyer today.
Yes, I appointed him to represent, well, his office to represent you.
Talk with me.
Just a moment, Your Honor.
Okay.
I didn't do anything.
All right, sir, I'm going to reduce that bond amount to $250, but you can't go back to Dank Smoke Shop. You understand that?
Yeah.
All right, good luck, sir.
That's even about, what you're talking about.
Please tell me your name.
Ashley Holton.
21 MM 6489. You're here charged with prostitution. I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $500. Are there any conditions the state would request?
Just no return to the area, Your Honor, which I believe is the mapping zone 42.
Yeah, all right. I'm going to order that you're not allowed to return to the area at Kaylee Avenue and Orange Blossom Trail. Do you know where that is?
Yes.
All right, so I need you to not be there, okay?
Yes.
All right, good luck, ma'am. Please tell me your name.
Brian Hopkins.
Mr. Hopkins, you're here in 21 MM 596 for violation of a condition of pretrial release. Let me pull up this case. It takes a minute. There is probable cause. I'll appoint an attorney to represent you. Can the state advise, are the out-on-bond cases domestic?
Yes,
See
Your Honor.
battery.
They're both battery, M1s, the victim being Mr. Koski. I don't know if there's relation, but it is just charged as a simple battery.
So wait, one is and one isn't?
No, they're both just simple battery, Your Honor.
Not domestic?
Yes.
All right, your bond on this is going to be $1,500. You understand that you cannot go back to this location for any reason at all. Do you understand that?
Yes, ma'am.
However, okay, I'm sorry. One of the victims was Mr. Koski. One of the victims was Miss Juanita, which is the case in.
Yeah, that's what I thought.
This case, there were 2 victims given the 2 battery charges, and it was at that 211 Ring Road address.
That's the location of the battery?
Yes, Your Honor. That he's out on bond for.
All right. Your bond on this charge is going to be $10,000. You can't go back to 211 Ring Road for any reason at all. Do you understand? Do you understand?
Yes.
Okay. You can't be within 500 feet of that residence for any reason at all.
Why is the bond so high?
Because, sir, you're out on bond for violent offenses. You were ordered by a court not to be in this location, and you were in this location. I need to be sure that you understand you cannot go back to that location for any reason at all. Do you understand that? You have to answer out loud.
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You can't have contact with any victim or witness in this case. And at this time, I'm revoking your bonds in 21 MM 5050. Good luck, sir.
To be clear, it was 10,000 and revoked.
It's what?
It was 10,000 on the new and
Yes.
revoked. Okay, thank you.
Please tell me your name.
Christopher Hosteller.
21 MM 6476. You're here charged with battery. I'm going to appoint an attorney to represent you in this case. I have to pull it up. There is probable cause. Your bond is $1,000. You can have no contact with any victim or witness in this case. Do you understand what no contact means?
Yes, ma'am.
You cannot return to the Walmart Neighborhood Market located at 902 Lee Road. You can't possess a weapon of any kind, firearm, or ammunition. All right, good luck, sir.
I don't understand because I didn't put my hands on anybody. I didn't hurt anybody. I didn't put my hands on anybody.
The only thing I'm telling you today is there's probable cause for the charge. I'm not telling you that the state's going to file it or that they can win at a jury trial. That's a very different burden. So if you think you have some defenses, you want to talk to your attorney right away and have them raise those defenses.
Can I just plea out? Can I just do it a certain amount of time so I can get?
I can't do that today because of the nature of this charge.
Nobody got hurt. Okay.
Good luck, sir.
Reynolds Anna, she bonded.
Okay.
Nicole Riley, refused court.
21 MM 417. I find her refusal a willing waiver of her appearance today. There's probable cause, and I'll appoint an attorney to represent her. Her bond is $500 with a no return to the scene. Please tell me your name.
Spencer Maurice Rutland.
21 MM 6471. You're here charged with resisting an officer without violence.
Yes, ma'am.
I'm going to appoint an attorney to represent you. Let me pull up your case. Give me one moment. Thank you.
Is it any possible way I can resolve that today?
Hold on one second. What'd you say?
Is it any possible way I can resolve that today?
So I don't know if the state is extending an offer, but I'm going to give you an opportunity to discuss with your attorney because I do believe this is one of the charges for which the state has a pretrial diversion program, which I don't know if you know how that works, but if you complete their program, they drop the charges. So you want to talk to your attorney about that?
Your Honor, there is no offer at this time, given that this came in due to him being a suspect of potential burglary for those cases to be combined at a later time. So there's not an offer at this time.
Okay. All right.
They said look-alike, and then they say he wasn't filing charges on it because that's not me.
That may be. The only thing we're here today for is the probable cause on the resisting without violence. There is probable cause, but that doesn't mean the state's going to charge it. I don't know what the state's going to do.
Charge me on this?
I'm sorry? Can I give you that? I'm sorry. Yeah, All right, sir, in this case, your bond is $500. Call your attorney right away. Or don't. That's all you. Sir, can you please tell me your name?
John Jordan.
Mr. Jordan, you're here in 21 MO 763. It looks like a capias was issued for your arrest for failing to appear on a charge of disorderly conduct. Is that right?
Yes, Your Honor.
Your Honor, could I have a moment to, there was an offer from the state, just a moment. I didn't have a chance to speak with Mr. Jordan.
Okay. I'm confused because it's labeled weird in here. The documents are. All right, Mr. Jordan. The state does have an offer for you?
Yes, Your Honor, an offer made was a withhold and credit time served due to being a city case.
Oh, I see. You had a chance to discuss that with an attorney, Mr. Jordan. Are you interested in accepting that today?
Yes, ma'am.
All right. Did the attorney have an opportunity to explain to you the rights you'd be giving up if you enter a plea of guilty or no contest?
Yes.
Do you understand those rights?
Yes.
Do you have any questions for me about those rights?
No.
Sir, it looks like your eyes are having trouble staying
I
open.
have a nerve disorder in this side of my face, and I just woke up, and the lights bother me because I used to weld, so they glare.
Okay, but you're not falling asleep.
Glare, yeah. Yeah, I'm wide awake. I have trouble with my eyes.
I understand. I just wanted to make sure, because if you're falling asleep and maybe this isn't a good time to do this, I want to make sure you understand all your rights.
Yes, ma'am.
You understand that if you're on probation anywhere, this plea could violate that.
Mm-hmm.
And if you're not a U.S. citizen, you can be deported.
Yes, ma'am.
And you just explained to me the nerve issue with your eye, and you just woke up, but I just want to make sure
Yeah.
you're not under the influence of any drugs or alcohol today,
No, ma'am.
or any mental health issues?
No.
All right. At this time, how do you wish to plead to disorderly conduct?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the time you've been in custody. I have to order that you pay court costs. Sir, do you have a job?
I have SSI, and once I get it straightened out, right now, my benefits have been sent to a nursing home, and they haven't seemed to straighten it out. I only get $30 a month, and because I'm paying rent there, but they don't realize it shouldn't be paid. And but I'm working on getting that straightened out.
Okay, so what I'm going to do then is I'm going to reduce that to a lien.
Okay.
Good luck, sir. You have 30 days to appeal in writing.
Yeah. 90 plus.
Were we appointing that case, Your Honor?
If I didn't, I am appointing them.
I just didn't know if we were appointing the underlying case. I think it was an FTA.
He was.
Oh,
I'm doing it.
then don't appoint us.
Oh, don't?
No, because then they have to pay another fee.
All right.
If we weren't appointed, we just spoke to him at the front of the court.
All right. Sir, please tell me your name. All right, sir, it looks like you have two capiases, 21 CT 5568 and 5569. One is for failing to appear on a no valid driver's license and one for no motor vehicle registration. The capias on the no valid driver's license, the bond amount is $2,000. On the no motor vehicle registration, it's $500. Is there an offer?
No, Your Honor, he was driving on a DUI suspension.
All right, I'm going to appoint an attorney to represent you at this time. Good luck, sir.
Sir, I can resolve this, excuse me, ma'am, I can resolve this right now?
You cannot, not today. But you have bonds on both, so you're not being held at no bond.
Yeah, I have no one to bum me out on this. I don't even have the money. I got a little 5-year-old daughter. I'm responsible for picking up every day from school. And if I'm in here, I'm gonna lose a lot of things. Is there any way I can plead no contest or something?
There's not, at this time, the state is not extending an offer, and I'm not inclined to accept a plea without that offer because there's a lot of information I would need. Like, for instance, the state just told me that the reason they're not offering anything is because these suspensions were for a DUI. So I would need a lot more information before I could give you a sentence.
Different. What about PTR, ma'am?
I can't change the capias. Hold on one second. James Drake.
Your Honor, it's in front of Judge Jewett.
Which one?
Steve.
Okay, thank you. All right, so here's what I have. Oh, the last FTA was these, okay. When was the DUI conviction?
He hasn't been convicted on it yet, Your Honor.
Oh, it's open?
I believe so.
I don't have an open DUI, ma'am.
It
I was
was,
charged DUI years ago, but I don't have an open.
it was a 2020 in orange.
It's from last year.
Yes.
I don't have an open DUI case. I don't know where they're coming from.
I don't either.
If I had one, I would have a warrant for or something, but I don't have an open DUI case.
I don't
I
know.
remember being arrested for DUI years ago, but that'd been years ago. And that was resolved back then. I don't have an open DUI case. I can assure you of that.
I don't know, and I don't even have a driving history on him. That's why I can't accept a plea today, sir, because I don't even have the information that I would need to do that. I don't have your driving record. And with the state telling me it's about a DUI, I understand you're telling me it's not. I believe you. I don't think you're lying to the court, but I don't have a way to look that up. So at this time, I'm not going to accept an open plea.
Can I be run back to court tomorrow or something?
No, you have to be brought in front of your trial judge, which is Judge Jewett. So if I were you, I would call the number on that piece of paper right away and ask your attorney to get you in front of Judge Jewett right away.
But I can deny me for something that I don't even have a charge for. I don't know what the the prosecutor's talking about.
I don't either, sir. I'm sorry, I can't, I don't have a way to look up the information.
Calhoun, Joshua, bonded,
He's what?
bonded.
Oh.
Sperling, bonded.
What about Hostetler? Christopher?
I think we heard that case, Your Honor.
Yeah. Still.
Christopher Hostetler? Oh,
Yeah, I thought we did him.
just kidding. All right, please tell me your name.
Clifford Charles.
21 CF 2457. You're here because a capias was issued for your arrest on a charge of possession of cocaine. There's no bond authorized, and the public defender's already been appointed. Good luck, sir. Oh, I already signed those. Yeah, I did. Please tell me your name. 21 CF 12333. You're here charged with burglary of a dwelling and trespass in an occupied structure or dwelling. I'm going to appoint an attorney to represent you in this case. There is probable cause.
Your Honor, we'd just like to bring your attention to his last conviction, approximately 5 months ago, also for a burg dwelling and petty theft.
His last conviction.
Yes, Your Honor.
But he was just released from prison and, oh no, he was on probation.
On probation.
So what was the sentence for the burglary of a dwelling in 21? Like in April of this year, he was convicted for burglary of a dwelling and he's out in August? I mean, that, on a score sheet, just that charge alone, he should be in prison, right?
Your Honor, due to how things are being pled right now, we're downward departing significantly generally. I don't know what a score sheet looks like. I don't have it in front of me. I could try to find it.
Right, but I'm just saying on a score sheet. I mean, it's been a little while since I looked at one, but isn't it like 56 points, which scores automatic prison time?
It sounds about right, also given he has other history. However, we've been downward departing depending on the case. So the burg dwelling petty theft was a case from 2019. He just pled to it 4/26/21. The dispo was orange. It was an adjudication, 23 months DOC with 13 days credit time served on the burg dwelling, and then an adjudication, 60 days OCJ with credit time served on the petty theft.
Wait, so how is he not in DOC?
I'm not sure, Your Honor.
Your Honor, can the defense be heard on bond conditions as well?
Yes, of course.
This isn't a PC challenge per se, but as to the facts of this particular case, I think there was an attempt to enter an alleged attempt into the garage area. It was unsuccessful. I know there's like a connected walkway between the house and the garage, but I would just have you consider that in your bond determination as well, that it was an allegedly unsuccessful burglary.
Your Honor, there was a pathway between the garage and it seems like the house that is covered by an overhang walkway that is enclosed. That in of itself is enough, as it's a roof over an enclosed building attached to a building.
What's also on the curtilage, right? It says
Also
had to enter the
curtilage.
fully enclosed fenced backyard. So burglary,
That's why I wasn't making the PC challenge. I was just.
I see, I see.
As to bond conditions, the facts of this particular case.
all right, I understand your argument.
Under consideration, yes, thank you.
So he didn't get anything from this house, but got something from another?
Allegedly, I don't know.
Yeah, how was he sentenced to 23 months DOC and he's here?
Trying to figure that out, Your Honor.
Yeah, so
Unless it was inputted wrong.
I'm not going to change the bond. I'm going to leave it at 5,000 on count 1 and 100 on count 2. You can't go back to this scene. Do you understand that? You can't have contact with any victim or witness in this case. You can't possess a weapon of any kind, firearm or ammunition. Good luck, sir. Please tell me your name.
Yana Dakotas.
21 CF 12361, you're here charged with possession of methamphetamine. I'm going to appoint an attorney to represent you. Hold on, let me pull this case up. There is probable cause. Your bond is $1,000. You can't have contact with any known drug dealers. You can't possess or consume a controlled substance of any kind without a valid prescription. Do you understand?
Yes, ma'am.
Your Honor, state would also ask for no contact with a co-defendant.
You can have no contact with a co-defendant in this case. At this time, I'm revoking your ROR in 21 CF 9372. I'll reset that bond at $2,000 on count 1 and $200 on count 2. Good luck, ma'am. Please tell me your name.
Keyshawn Epps.
21 CF 12335. You're here charged with robbery with a firearm, armed burglary of a conveyance with a firearm, and criminal mischief. At this time, I'm going to appoint an attorney to represent you. Did the state wish to be heard?
Yes, Your Honor, as to count 1, the robbery with a firearm, it is a punishable by life offense. State is asking that you hold him no bond pending an Arthur hearing, and to stay the 2 additional bonds on count 2 and count 3, one being an F2 and one being an M1.
No argument, Your Honor, pending that Arthur hearing with his attorney.
All right, and there was a warrant issued, so another judge has already found probable cause. You'll have no bond on count 1. Hold on one second. Count 2 will be $25,000. Count 3 will be $500. You can have no contact with any victim, witness, or co-defendant in this case. You can't possess a weapon of any kind, firearm, or ammunition. I'll order that you have to surrender all firearms to law enforcement within 24 hours of your release. You're not allowed to return to the scene for any reason. Do you understand?
Yes, ma'am.
Good luck, sir.
Your Honor, he has another case, I believe, as well.
Another,
Seen on that.
Okay.
yeah, I don't have that.
Erickson, bonded.
Okay.
Who? Vic?
Erickson, yeah.
Oh.
Pickett, she refused court.
Amethyst?
Yes.
21 CF 12366. I'll find her refusal a willing waiver of her appearance today. I'll appoint an attorney to represent her. There is probable cause. Hold on one second. I'll stay the bond at $1,000 with a no return to the scene. Please tell me your name. All right, you're here in 21 CF 12341. Let me pull that case up. I'm going to appoint an attorney to represent you.
I didn't do none of this
Yeah.
stuff, ma'am. He keep
Hold on,
putting
it's
this
okay,
on me.
it's okay. Your Honor, can I approach with case law as well as a evaluation?
Sure, yes.
I have the evaluation.
Hold on, let me tell her what she's being charged with. You can come on up. It's attempted arson, criminal mischief, trespass on property after warning, aggravated assault with a deadly weapon, burglary of a dwelling, and battery. Those are the charges here today.
Them the same charges he keep putting me on, and them the same charges he keep dropping the same repeatedly.
Okay.
My lawyer know that's my address. I don't know why he keep putting me in jail, and the police, he broke my jaw, ma'am, and the police. I'm sorry. I don't like that.
So ma'am, everything you say right now is being recorded and can be used against you later. Do you understand that? All right, give us another minute, ma'am. I have to talk to the attorneys about some things.
Yes, ma'am.
All right, so is this case law about competence or probable cause?
Case law is about probable cause to the attempted arson charge.
Okay. So do you want to start with that?
Yes, Your Honor. For the record, I did provide co-counsel, or opposing counsel, as well as the court, a case law, Costin v. State of Florida, 765 Southern 2nd, 52. It talks about the combination of the arson, the Florida arson statute, as well as the Florida attempt statute. And the last paragraph, in order to establish the crime of arson, the state must prove that a defendant willfully and unlawfully caused damages to a dwelling by use of fire or explosion. The attempt statute provides that a person who attempts to commit an offense and doesn't act towards the commission of that offense but fails to complete it commits the offense of attempt. A plain reading of these two statutes indicates that a defendant can be convicted of attempted arson by willfully and unlawfully attempting to cause damage by use of fire or explosion. In this current case, the facts allegedly indicate that the Ms. Fisher allegedly used gasoline on 2 of the victims as well as in the house, but I did not find an attempted use at fire or explosion to catch the house on fire. He ran out of the house allegedly and allegedly attacked another alleged victim. So I don't believe the course of action rose to the level of even attempted arson, Your Honor.
All right, what says the state?
Your Honor, this case in and of itself says that attempted arson can be sustained. I know it goes into the Gray case and the legal fictions being regarding felony murder. So while this case is on point, it's also kind of not. Intent is a question for the jury. This case also goes to not a PC finding, it goes to a trial finding. It says that attempted arson can be found, so it's not a legal fiction, but the state would contend that pouring gasoline on victims and a house, or a house that she's already not allowed to be at and has been trespassed from several times, would be enough to show an attempt to try to do that. It says unlawfully attempting to cause damage by use of fire or explosion. She attempted to do so. And she attempts to commit an offense and did an act towards the commission, and a significant act in this case, pouring gasoline. The commission of that offense arguably would have been completed had she had the other things. So she did take a substantial step to commit this offense, but failed to complete it.
So I appreciate both arguments. I'll tell you where I am, and Mr. Brantz, you can tell me if you can move me from this. I didn't read it exactly the way the state did. How I read it is she poured the flammable liquid on the 2 women who ran out the door. So the intervening act that prevented her from completing the act of the arson and the battery is they ran away, and then she ran out in the yard to batter someone with a weed eater, and then I think it was a weed eater, but then law enforcement arrived, and so she ran. So it doesn't look to me like the reason I think it's an attempt is she was interrupted in the process of committing the crime. That's how I read this affidavit. So are you reading it differently?
A little bit, Your Honor. Gasoline can be an irritant. If she's trying to batter, even, I don't know if gasoline is considered a deadly weapon, but I saw more so a battery. But then I was missing a fact that would suggest that, let's say a hypothetical defendant grabbed matches, but then ran out, or was finding something to create a fire or explosion in the house, and that just wasn't here. The gasoline was here, but there was a missing point, I guess, of intent to then commit arson.
For an attempt, you only have to take a substantial step to achieve that crime.
Right.
In this case, she took a substantial step by pouring gasoline on the victims as well as, I believe, some of the house. So arguably, there's an attempt has been completed by her taking that substantial step to complete this crime.
Yeah, I think that the pouring the gasoline is the substantial step. We're beginning the attempt, and then she was interrupted because they ran, so then she ran out of the house too and didn't complete it. But I think there's enough for probable cause. Whether the state can sustain it at jury trial is a completely different question. But I do think there's enough for at least probable cause for the attempt. So then do you wish to be heard on bond?
As to bond, Your Honor, I did provide the state and the court with a current evaluation of incompetency, permanent incompetency to proceed from January 21 from Dr. Elias.
What case was that in?
Your Honor, state would just argue, it's one evaluation. There has not been an order. So she has not been found incompetent. I don't believe there's an order to that case. And if it's from January, it arguably would be stale for this instant case.
The case, according to the evaluation, this would cover cases 2019 CF 17357, 19 CF 11619, 19 CF 6666, 2020 CF 12380, 2020 MM 9307, 2020 MM 8412, and as to staleness, I believe a competency evaluation isn't stale until another evaluation has been completed showing competence, but in the conclusion of this, Dr. Elias, there's a permanent incompetency to proceed. So
But there's no order, right? So that's one evaluation. To the state's point, what would happen is you'd have a hearing in front of the judge, you'd present that evaluation, and then the state would have the opportunity to say, we object and we ask the court to appoint another expert. Like, we haven't had a competency hearing on this, right?
I understand, Your Honor, and I wish I had the time to adopt the findings of in another court case to deem them incompetent in these cases as well, but all
Right.
is the evaluation to argue that you don't revoke and set at none in the out on bond case. I would just have you take no action.
Well, that evaluation is not in either of these cases. So what we have is she's out on bond and for battery and burglary of a dwelling and criminal mischief. And then it allegedly commits attempted arson, burglary of a dwelling. It's very violent offenses, right?
I understand, Your Honor, but incompetency is tied to a person, not a case, even though we do have to adopt findings of the incompetency. In other cases, case law suggests that in the legal sense, incompetency carries with the person, not the case. Even the evaluation is in other cases, it's still tied to this defendant.
Right, but there has to be a hearing, which hasn't happened in any of these cases. It actually hasn't happened in that case either. So there was no hearing where any other experts were appointed. You have one doctor's findings and no order from any court, right?
I understand. I'm not asking you to order. I'm just using this as a plea to the court to not take action on the en banc case.
Yeah, I understand, and I'll have to tell you I'm torn. I appreciate that you did that. But what I'm worried about is we have violent offenses while out on bond for violent offenses. This seems to be an escalating pattern. I think that if I were you, I would encourage the people in my office to file some motions in these cases.
Yes.
Because you don't have an order, and that's a 9-month-old evaluation. Why has nothing been done on that?
I'm sure there has been something done. That was just all I could produce today, Your Honor.
Your Honor, in her out on bonds, I don't know if it's helpful to you, the 7762 Berg dwelling criminal mischief case also occurred at the same residence in 625 Indiana.
All right, so here's what I'm going to do. I'm going to set your bond on count 1. Your bond will be $20,000. I'll stay all the other bonds at 100 on counts 2 and 3, 150 on 4 and 5, 100 on count 6. You can't have any contact with these victims or witnesses. Do you understand what no contact means?
What's 20,000? I can't afford that.
The attempted arson,
20,000?
right.
I can't afford that.
I understand. Your attorney can file a motion to reduce it, but for now, that's what it is. But do you understand what no contact means?
Yes.
Okay, you can't possess a weapon of any kind, firearm or ammunition. You also can't return to this house for any reason.
I never did no attempt or nothing. They keep
Okay.
going off what he say. They're not letting me write no statement on him or nothing. They keep going off on every person that be there, and he keep lying on them, and they not doing anything about it.
So here's what's gonna happen. I've appointed an attorney to represent you. It sounds like you think you have defenses in this case. You'll have an opportunity to raise those defenses.
I'm not gonna be able to go to trial. I'm not gonna be able to do none of that.
But even if you can't go to
I'm
trial,
gonna keep pushing this off like,
no ma'am, they're not. I just asked Mr. Brantz if he would please make a note for his colleagues that they need to move along that evaluation. And maybe that can be,
no, because I'm permanent incompetent. I don't know why they.
we need to have a hearing. You have to have a hearing in front of a judge. No judge has found you incompetent.
Now, you sure?
Yes.
I didn't know that.
Well, it hasn't happened in these cases that I have. Now, maybe in the past, another judge has. I don't know that. But in this case,
But that's fine. I just.
but no judge has said that. So we need an order from a judge.
Okay.
So that's what I'm asking Mr. Brantz to do, is to contact the lawyer who's going to be representing you moving forward to get this in front of a judge, okay?
So why is my bond so high like this? He did this before with somebody just to get insurance money, and y'all not doing nothing about none of this.
So there's nothing I can do about any of that.
Fine, but I ain't gonna be able to talk in there, so.
I don't want you to talk to him.
Insurance money.
I don't want you to talk to him at all. I only want you to talk to your attorney, okay?
I'm letting y'all know he did this and just did this recently, last year, February, for insurance money.
So tell your attorney that so that they can investigate it. I can't investigate that.
Y'all keep doing this to me like every time, and it's not fair. These are fake charges he keep putting me on.
All right, ma'am. Good luck.
Thank you.
No action on the bond.
I'm going to revoke those, Mr. Brantz. I'm going to revoke her out on bond cases. So have those attorneys file motions in all those
Them
cases.
charges was dropped. I don't have them charges no more. They didn't put that in there either.
No, it shows that you have 2 pending cases right now.
That battery?
One is battery, one is burglary of a dwelling.
Mary Hamilton, she refused court.
21 CF 12367. I'll find her refusal a willing waiver of her appearance today. Appoint an attorney to represent her. Her bond is $1,000. No return to the scene, and there is probable cause. Please tell me your name.
What's your name?
Luis Hernandez.
Thank you. 21 CF 4927. You're here charged with first-degree murder. Let me pull up your case.
Your Honor, we have actually filed an information. We filed a second-degree murder with a
Second-degree.
firearm, which is also still a life offense. So state is still asking that you hold a no bond pending an Arthur hearing.
All right, I'm going to appoint an attorney to represent you, Mr. Brantz.
No argument from the defense, Your Honor, pending an Arthur hearing with his attorney.
All right, so you were originally, a warrant was issued for your arrest charging you with first-degree murder, but the state filed it as second-degree. So I don't need to find probable cause at this time. You will not have a bond until your attorney files a motion for that in front of your trial judge. But even while in custody, you can have no contact with the victim's immediate family. Do you understand that? You have to answer out loud.
Yeah.
All right, good luck. Please tell me your name.
Marshall Lamar Jackson, ma'am.
Thank you, sir. 21 CF 12355. You're here charged with 2 counts of possession of a controlled substance, 1 count of possession of paraphernalia, and 1 count of resisting without violence. I'm going to appoint an attorney to represent you in this case. Give me just a minute, I gotta pull it up. There is probable cause. All right, I'll stay your bond at $1,000 on count 1, $150 on count 2, $100 on 3 and 4. You can have no contact with any known drug dealers. You can't possess or consume any controlled substance without a valid prescription. Do you understand? No. All right, good luck. Please tell me your name. 21 CF 9764. You're here charged with robbery with a firearm, grand theft, and possession of a firearm by a convicted felon. I'm going to appoint an attorney to represent you. Let me pull up your case. Does the state wish to be heard?
Yes, Your Honor, as to count 1, the robbery with a firearm, as it is a life offense, state is asking that you hold no bond pending an Arthur hearing.
All right, and this is a warrant, so another judge has already found probable cause. What says the defense?
No argument, Your Honor, pending an Arthur hearing with this attorney.
All right, at this time, you'll have no bond on count 1. I'll stay count 2 at $1,000, count 3 at $2,500. You can't have contact with any victim, witness, or co-defendant in this case. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. I'll order you have to surrender any firearms that you have to law enforcement within 24 hours of your release. All right, good luck, sir.
He has a
Wait,
violation of probation.
hold on 1 second. Thank you.
No, I'm sorry. He'll be sealing it tomorrow.
I was like, I don't have that.
Proceed.
I do show that he's a violent felony offender of special concern. All right, good luck, sir. Please tell me your name.
Ryan Oliver.
You're here in 21 CF 6585, possession of fentanyl, and 21 CF 12350, trafficking in fentanyl, 4 grams or more, unlawful use of a two-way communication device. I'm going to appoint an attorney to represent you in both of these cases. Hold on 1 second.
Yeah, well, hold on. Your Honor, can our client be heard on bond condition?
Yes, do you want to speak to the court?
Please, if possible.
You understand that everything you say is being recorded and can be used against you later?
Yes, I do.
All right, go ahead and raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, I do.
Thank you.
All right, go ahead, sir.
I was just asking if PCR was an option at all. I've had it before. I've gone through the entire process correctly, and I was just asking if that all was possible.
Unfortunately, it's not because of the charges. You don't qualify for pretrial release in these cases.
He's also out on bond, Your Honor.
And you're out on bond. For possession of meth, amphetamine, I'm guessing, and drug paraphernalia. So, no, sir, you don't qualify for that. All right, at this time, your bond is $100,000 on the trafficking, $150,000 on count 2. You cannot possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. I'll set your bond at $1,000 in 21 CF 6585 with the same conditions, but at this time, I'm going to revoke your bond in 20 CF 14458. Good luck, sir.
Give us a call.
Yes. Please tell me your name.
Denise Anisha Price.
21 CF 12370. You're here charged with prostitution, third or subsequent offense. I'm going to appoint an attorney to represent you. There is probable cause. I'll stay the bond at $1,000. Ma'am, you can't go back to this area. Do you understand? Don't go back there. Okay.
Yes.
Good luck, ma'am. Please tell me your name.
Adam Quintana.
21 CF 12195. You're here charged with fleeing or attempting to elude law enforcement. I'm going to appoint an attorney to represent you. I need to pull this up really quickly. This is a warrant, so another judge has already found probable cause in this case.
He does otherwise qualify for PTR, Your Honor.
I turn myself in, ma'am, and then I'm willing to appear to every court you approve.
Your Honor, for the record, state would object to PTR. If you're otherwise inclined to put him on it, state would ask for PTR and bond. I believe law enforcement tried to stop him approximately 2 to 3 times, in which he fled each time. One time pulling into the turn lane, stopping, and abruptly re-entering the main lane, fleeing from the traffic stop the next time, fleeing at a high rate of speed, when officers terminated the stop due to office policies regarding the safety of others. It should also be noted, through investigative means, they were able to determine Mr. Quintana Molina was the defendant. But in addition to that, there were other calls for service at least 4 times regarding his vehicle driving recklessly in the area. Given the dangerous nature of the offense, state would object, but would otherwise ask for PTR and bond if you are inclined to put him on PTR.
Do I do that a lot for fleeing or attempting to elude?
Not generally, Your Honor, that I've noticed between you and Judge Bain. My only argument regarding PTR is he showed an inability to comply with law enforcement. I don't know why he would comply with the conditions of PTR.
Yeah, I don't.
I'm sorry. Can I be heard to supplement
Yes,
my argument, Your Honor?
yes, please.
As to this particular case, and Mr. Molina, very little criminal history if, other than a arrest for no valid, provided all the relevant information to pretrial services to qualify, including the name of the company he works at, where he's worked for 8 years. I believe pretrial release is designed for these kinds of cases where they don't have to post a monetary bond. There's no real risk of flight.
I mean,
Your Honor, his
really, you see the irony of that statement. There's no risk for flight when we're here for, I'm reading the multiple times he fled from law enforcement at a high rate of speed, putting the citizenry in danger each time he did it, right? That's what I'm reading.
Yes, Your Honor, but we do allow pretrial release for battery cases, which are crimes against person. I don't believe
Yes.
this current charge or any of his history of driving without a valid license is any crime against a person.
Your Honor, I'm not sure if it's correct, but I'm unsure about his community ties. I understand he said he has his own landscaping business, but per the affidavit, his citizenship says Mexico. So defense makes an argument that he's potentially not a flight risk. However, I do not know if that is completely accurate.
What would be the conditions on pretrial release for a charge like this, Mr. Brands?
Driving without a valid license, or I think you could order him not to drive at all.
Or what?
Or you could order him to not drive at all. But other than that, I don't see any reason to, other than the driving related condition.
Mr. Quintana, do you have someone who can drive you to work?
Yes, ma'am.
All right, here's what I'm going to do. I'm going to place you on pretrial release and require that you post a monetary bond. I'll reduce that amount in half. So your bond is $7,500. You can't drive while on pretrial release. So someone has to drive you everywhere, you understand?
Yes, ma'am.
You can't have contact with any of the witnesses in this case. You understand what no contact means?
Yes, ma'am.
All right, good luck, sir.
Thank you, sir.
Rivera, Mr. Vito Medical.
21 CF 11628. Mr. Brandt, I'm going to appoint your office.
We'll waive the appearance, Your Honor.
All right, there is probable cause. Bond is $15,000 on count 1, 100 on count 2. And I'm revoking all the out on bonds. Do you have,
I'm sorry. No, they brought it over.
is Ruiz coming in? No.
Rivera?
That's the deal, yes.
What, at the end? Okay.
Well, I have Rivera right here, Your Honor. They brought it over.
All right, this is 21 CF 11628, ma'am. Tell me your name.
Rivera Acevedo.
All right, I appointed an attorney to represent you. There is probable cause. I set your bond at $15,000 on count 1, 100 on count 2. And because you're out on bond for racing on a highway, reckless driving, and no motor vehicle registration, I revoked those bonds. Good luck, ma'am. Please tell me your name.
Jose Ruiz.
Okay. I think we have an attorney on the line.
Welcome to an Econo meeting. You are entering the meeting now. You are the only participant.
Are you represented by Mr. Adam Reese?
Yes, ma'am.
Okay, hold on 1 minute. He's supposed to be online. Let me see if we can get him. Do you want to bring someone else out while we're waiting on him to connect? All right, sir, can you tell me your name?
Joseph Sanchez.
21 CF 12349, you're here charged with aggravated battery with a weapon and battery. I'm going to appoint an attorney to represent you. Hold on, I got to get out of this case and get into your case. We have an attorney. Counselor, give me 1 minute. I took another case in the meantime, but I have your client right here in the courtroom, so just give me 1 minute. All right, Mr. Sanchez, there is probable cause here. I'll stay the bond at $3,500 on count 1, $100 on count 2. You can have no contact with the victims or any witness in the case. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. All right, good luck.
Your Honor, I understand that they're both employees, but say we still ask for a no return to the area.
I mean, it was a job site, right?
Yes, it was a job site.
So I don't know that he has control over where they send him, but he has a no contact. So you'll have to tell your work
Yes,
that you can't work where he is.
yes, for sure.
But I don't know what if they send him back to that job site?
That's my only concern.
I will make sure they won't set me back.
Okay, then I'll order that you're not allowed to return there.
Yes.
Okay, all right, good luck, sir.
All right, thank you.
Thank you.
Can I see that?
All right, let's go back to Mr. Ruiz. Sorry about that, counselor. Oh, you're on mute. Oh. Nope, I still can't hear you. I can see you, if you can hear me.
I can hear you. Can you hear me?
Yes, now I can. Wonderful.
Oh, I apologize. Okay. First off, I want to thank you for accommodating. I'm in the middle of a deposition, so
Of course.
kind of multitasking here, but I very much appreciate you accommodating me. Thank you.
Listen, if there's one thing this technology has proven we can do, it's multitask, right?
Well, it's interesting. My deposition is, it's almost like we're from different planets. The connection is so bad.
Oh, well, sorry about that. All right, we'll try to make this
all
one
right.
quicker. All right, Mr.
I
Ruiz,
appreciate it.
you're here because a capias was issued for your arrest in 15 CF 15124. The capias was issued for, it's a probable cause order, charging you with leaving the scene of an accident with death.
We have filed an information, Your Honor, so PC was found back in 2015 when we filed that information.
Charging the same thing?
Leaving the scene of an accident with death, yes.
Okay, all right, so the state has actually filed a charging document with that information. So counsel, I assume you want to be heard on bond?
Yes, ma'am, I would. I don't know if the court has had an opportunity to review the information attached to the information, but the alleged conduct which led to the filing of charges occurred March 18th of 2013. Approximately 2.5 years later, this charge that my client is currently facing had an information filed. My office has filed a notice of appearance. We are in the case. There are some documents that I did have my office file received this morning, 2 character reference letters that are available online, as well as the fact that my client is gainfully employed for a company called Aqua Dry, which is basement waterproofing. And his company has written a letter on their letterhead, which was filed, indicating that Jose does have his job available to him if he was to be released. It's my understanding that he currently resides with his wife and 3 children in Pennsylvania. And as I mentioned, we have filed a notice in this case, and it's my belief that my client will make himself and continue to make himself available. Additionally, I've spoken with the family, and I'm going to speak absolutely without any kind of reservation that the most bond they would be able to raise would be currently a $20,000 bond using $2,000 as the premium because that's the only funds they currently have available. That Jose has been in custody for quite some time, and although his job's available, right now his wife is basically a single mom with 3 kids and trying to, keep the roof over their head.
But he lives in Pennsylvania?
That's correct, Your Honor. Now, I did speak to the family, and they indicated that they're going to try to rent a place here in Orlando, but that's also another financial burden. The bottom line is, as I mentioned, the conduct alleged to have occurred was in March 18th of 2013, and 2.5 years later, the charge was filed, and it's my understanding that that Jose had been in Central Florida that entire time period and actually contacted the authorities to find out if anything was taking place with it, and was not given any information.
All right, what says the state has to bond?
Your Honor, there has been extradition requests from Pennsylvania to get him. I believe he was in custody in Pennsylvania at least the better part of 2020 and 2021. Given that he is from Pennsylvania, I understand counsel has made the argument that they're potentially going to try to find a residence here. However, given that he does reside in Pennsylvania and his wife and children are still in Pennsylvania, state would contend that he is at least partially a flight risk due to having ties and significant ties to Pennsylvania. I understand counsel's argument that this occurred in 2013. We didn't file till 2015. However, I don't believe that goes to the bearing of his bond and what should be set. The facts of the case should be what is bearing on the bond that is set in this case. In this case, there were 3 independent witnesses. The victim was a pedestrian with the walk signal. The defendant allegedly ran a red light, according to all 3 independent witnesses, at a high rate of speed and never stopped. He later then was addressed by law enforcement about his car and why it was missing a rearview mirror, and did not give any answers to law enforcement and gave other excuses. Also, given that it is an F1, I think $20,000 is incredibly low, given that it's an F1 and there was a death that resulted. And given his history, he does have a prior probation violation.
I believe that was for misdemeanor marijuana.
Regardless, he violated a court order. He has an out-of-state warrant or an out-of-county warrant for Osceola, and he has other multi-state history of convictions and arrests. Just given the facts, his history is not strong ties to Florida, and the facts that are alleged to have occurred, state would ask for a much higher bond than $20,000.
What's much higher in the state's opinion?
At least $100,000, Your Honor. It's an F1. There was a death, and the facts alleged are concerning.
All right, thank you. Counselor, did you want to respond to any of that?
Well, Your Honor, I don't have access to my client's criminal history. I don't know what exactly the state is talking about. Bottom line is the family has retained counsel. We filed our notice of appearance about a week and a half ago, and I believe that in these circumstances that a bond is authorized, and we would ask to set a bond in an amount that is affordable, that would also assure the return of my client to face the allegations. And I do believe that the fact that the state waited 2.5 years to file charges does create a significant problem with a number of factors. But he was residing in Florida when that happened, and nothing had taken place. And I think that a $20,000 bond is clearly reasonable.
All right, thank you, Counselor. I appreciate that, and I do think I agree with you on several of your points. I see the state's points as well. Just so you both are aware, I have a note that says he has an active warrant out of Osceola County. I don't know what that charge is, but that might be served on him soon.
It's a VOP.
Oh, it's a VOP?
He actually has,
What kind of a case? Excuse me, I'm sorry.
it's a VOP for possession of marijuana and drug paraphernalia, and then he also has another VOP for driving while license suspended, revoked with a no bond.
Were those from 2014?
Yes.
Okay, so wait, what's the last one you said?
A VOP for driving while license suspended and revoked with a no bond.
Has that warrant been served on him?
That one has not been served.
All right, did you hear that, Mr. Reese?
Yes, ma'am. And is that also out of Osceola?
Yes.
So that one, I would think is your biggest concern because there's no bond on that. So when that gets served on him, he'll be held at no bond.
Well, I understand.
I understand that's not relevant to today, but I just want to make sure that you're aware of that because
I do appreciate that. Thank you, ma'am.
I do believe he's entitled to bond today. Just so that both of you are aware, while you were talking, I pulled up the bond schedule. This court does not adhere to a bond schedule. You are all aware of that. But I do often use it as guidance and in connection with the facts of the case, the criminal history, the other relevant facts that the court has to evaluate, such as community ties versus not. So I just want to tell you that I looked it up, and according to the bond schedule, the bond for leaving the scene of a crash involving death, the recommendation is $10,000. I'm not inclined to set it at $10,000. I find that extremely low. However, given that that's the guidance, I think I will grant the defense motion and set it at $20,000. I'm slightly concerned that he lives out of state and has tenuous ties here to the area. However, I think that bond and also defense counsel being involved in the case at this stage now, I'm going to believe is sufficient to secure your client's presence for court dates. Now, I don't know, Counselor, you're going to have to make sure that you stay in touch with him about what this
Absolutely.
court is going to do, because I don't know what things are remote and what things are in person, and I don't want him to miss something.
No, ma'am. And I've been in contact routinely with his wife, who, by the way, has no prior criminal history and is very diligent and has maintained contact with me very politely and respectfully, has maintained contact.
All right, and I just want to also advise both attorneys that I was able to review the filings from the defense in the court filings, in the court case. So that also played a part in my bond determination. The only conditions that I'm going to place on you, sir, are you can't drive without a valid Florida license, you can't have any contact with any victim or victim's family members or any witness in this case. So you understand what no contact means?
Yes, Your Honor.
I don't imagine you would have contact with them after this many years, but I just want to make sure that you don't.
Yes, Your Honor.
Well, Your Honor, can it say without a valid license and not specifically Florida license, since he doesn't reside here?
But if he does for longer than, what does it say, like 10 days or 30 days, he has to have a valid Florida license.
Okay.
But I'll say valid license, because that would, you're correct, it would make it, it's not valid if he's here for longer than that statutory requirement. So.
Well, hopefully that won't be an issue. I thank you very much. And once again, I appreciate your accommodation.
Yes, sir. Good luck with your deposition. Good luck, sir.
Thanks very much. I only have like 7 questions left.
All right, well, hopefully you wrap it up soon.
Thank you again.
All right,
Bye-bye.
thanks. Bye. Please tell me your name.
Deanna Scott.
21 CF 12356. You're here charged with possession of cannabis greater than 20 grams. At this time, I'm going to appoint an attorney to represent you. Hold on, I have to get out of the bond schedule now. There is probable cause. I'll stay the bond at $1,000. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. At this time, I'm revoking your bond in 20 CF 14580. Good luck, ma'am. Call the number on that piece of paper to speak to your attorney. Good luck, ma'am. Please tell me your name.
Laura Stats.
21 CF 12369. You're here charged with possession of fentanyl and prostitution. I'm going to appoint an attorney to represent you in this case. Give me a moment. Let me pull it up. There is probable cause. Your bond is $1,000 on count one, $500 on count two. You can't possess or consume any controlled substance without a valid prescription. You can't have contact with any known drug dealers, and you can't return to the area at Orange Blossom Trail and 23rd Street. Do you understand?
Yes, ma'am.
Good luck.
Your Honor, would you consider count two a subsidiary and set it at 100, so 500?
I'll tell you why I didn't. She was convicted of the same charge 4 months ago. But yes, I'll do that. So I'm going to reduce the bond on count two to $100. Sorry, go ahead, Ms.
I
May.
believe she has an Orange County warrant and a Georgia warrant that are open, active.
Oh, it does say that. I don't know if she's going to be able to bond out, Counselor. She has some active warrants.
Thank you, Your Honor. I'll
All right, good luck, ma'am.
give her our office's number.
Okay.
What to talk about.
Please tell me your name. 21 CF 12352. You're here charged with possession of methamphetamine and possession of drug paraphernalia. I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $1,000 on count one, $100 on count two. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Good luck, sir. Please tell me your name.
Demetrius Watson.
21 CF 9773. Sir, you're here because a warrant was issued for your arrest for violating your requirements as a sex offender. Another judge has already found probable cause. I'm going to appoint an attorney to represent you. Sir, do you wish to testify today?
I do.
All right, raise your right hand, please.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, to help you God?
I do.
Please state your name for the record.
Raymond Lucas.
All right. Does the state have any questions for this witness?
Do I have any questions?
No, the state. I'm asking if the prosecutor wants to ask you any questions.
Oh,
No, Your Honor, other than whatever he would like to tell the court.
What?
This is Mr. Watson, correct?
No, yes, this is Mr. Watson. Sorry.
No, Your Honor, other than whatever he would like to tell the court.
All right, let me ask Mr. Brandt, do you have any questions?
What's your relation to Mr. Watson?
just a friend and roommate.
And what would you like to tell the court today?
I really don't know how all this works, but I'd like to ask if he could be released on his own recognizance.
Recognizance?
Thank you. I've had a stroke, so bear with me.
It's okay. That's a hard word for most of us to say regularly.
I know. He is gainfully employed. He does not want to lose his job, of course. He loves his job. He's been keeping his nose clean since he got out of prison. And to me, the charges are just, well, I don't really want to know if it's trumped up charges, but I mean, I don't know what to say other than, I think he's a good guy. I'd like to give him a chance.
Well, thank you, sir. I appreciate you doing that today. So the warrant was issued because it looks like, Mr. Watson, you're registered as a sexual predator, and the allegation for which another judge found probable cause
Yes.
is that you didn't register a motor vehicle.
Yes.
Well,
Listen, I'm not asking you to defend it today. You don't need to do that. Everything you say is being recorded and can be used against you later. I just want to make sure you understood what the charge is.
Yes, that's why my witness was here to verify about the vehicle. I don't mind talking about it because I'm not lying. So,
Well, I still want to ask, before you say anything else,
yes.
do you want to talk to your attorney for a minute?
No, I want to talk. I want to say,
Hold on, let me ask Mr. Brands if he wants to talk to you.
Just a moment to confirm.
All right. I just want to make sure he understands that anything he says to me is being recorded and can be used against him. So I'm allowing him to talk to his attorney for a moment first, because his attorney might want to give him some advice.
absolutely.
Does the state have the out on bond?
Yes, Your Honor, would you like the affidavit?
Oh, yes, do you have that?
That was going to be the state's argument, Your Honor. Is the out on bond is also sexual in nature?
Yeah. All right, Mr. Watson, after speaking with your attorney, do
Yes,
you still
ma'am.
want to talk to the court, or do you want to wait?
I want,
Your Honor, can I approach?
Yes. Give us 1 minute. Let the attorneys talk again. Sorry
yes,
about that.
ma'am.
All right, sorry about that. I had to talk to the attorneys. Mr. Brands, do you need to talk to him one more time, or do you want to make an argument for the court?
Can I question the witness again?
Yes.
Are you roommates with Mr. Watson?
Has he been sworn? Okay, thank you.
Did we swear him? I thought so. Yeah.
Are you roommates with Mr. Watson?
We are.
You own a vehicle?
I do.
Does Mr. Watson's name appear on the deed to the vehicle or the title to the vehicle?
Not at all.
Do you allow Mr. Watson to drive the vehicle at all?
No, sir.
What is his usual mode of transportation?
He rides a bicycle. He rides it all the way downtown Orlando to work. He goes everywhere.
Thank you. I appreciate you coming to court today. Your Honor, as to the charge of failing to register, I believe he had to report that he had a motor vehicle, but according to witness testimony, he doesn't drive the vehicle. He doesn't own the vehicle in any way. I would just challenge the PC, the probable cause for the current charge, Your Honor.
All right, so I appreciate the argument. Because it's a warrant, probable cause was found by another judge, it doesn't mean this court can't change that judge's finding. However, this court is loath to do that. But I'm going to point you to a line in the affidavit, Counselor. I think I understand your client's confusion. It says that your client listed no motor vehicle as registered or co-registered to him or his permanent address. So I believe, and I'd have to pull the statute up, that if there's a vehicle registered at the address where he resides, he has to report that too, even if it's not registered to him.
I understand that, Your Honor. I feel like there wasn't a criminal intent there to fraud the report in his sex offending report.
Right, let's look at the, hold on. Let me tell you this. It says Florida Statute 775.21 sub 2 sub O, which states, vehicles owned means any motor vehicle as defined in Florida Statute 320.01, which is registered, co-registered, leased, titled, or rented by a sexual predator or sexual offender, or a rented vehicle that a sexual predator or sexual offender is authorized to drive, or a vehicle for which a sexual predator or sexual offender is insured as a driver. It also includes any motor vehicle which is registered, co-registered, leased, titled, or rented by a person or persons residing at a sexual predator's permanent residence for 3 or more consecutive days. So I think what the Florida statute says, because he lives in the same house you live and you have a car, he has to report that car as well.
Right, and he just was not aware of that.
I understand that. That seems like a valid defense.
Yeah.
But he can't raise it today. It doesn't do him any good to raise it today, because the only thing we're doing today is talking about probable cause. I think there is probable cause because the law enforcement officer went to your residence, they saw the car there, they spoke with you, they know that it's your car, but it's at the same residence where he is, and he didn't report it. So I think there is probable cause that he violated that part of the statute. Now, that does not mean the state is going to file that or prosecute this to a jury trial. I don't know what the state's going to do, and I'm not telling you a jury will convict him. This is just about probable cause today.
Your Honor, and I just spoke with Mr. Wilson, and if he can bond out today, he's assured me he's going to report that motor vehicle as soon as possible.
Mr. Watson?
Yes, ma'am.
Mr. Watson, I'm sorry.
I just want to make sure we're talking about the same person.
Yes, Mr. Watson. He's also been employed with that Labor Ready temp agency for the last 6 months, so he has been diligent in going to work and trying to keep up his reporting.
And I want to pay my court costs and stuff too. I got my driver's license I want to pay for it to be suspended, and my court costs from last time. I'm trying to pay all that, and I've been working steady. I promise you I'll straighten this out. I'll go straight to the sheriff's office and put every car that's on that property. I was under the impression I only had to do my car if I had a car. I never knew that I had to register their car, because the DMV wouldn't let me do that anyway because it's not in my name or nothing. So I thought I couldn't have to do that. When I stayed at a hotel, it's a bunch of cars there. I would have to report all those cars in the parking lot. It's like it's just like, I mean,
Actually, that's a really good argument.
I mean, like, for real, if I move in a hotel, all those cars are accessible to me. So how could I
Right.
report all those cars?
I understand. I understand your argument. I think you have some defenses you might want to raise, but you're going to have to talk to your attorney about those. So,
I just want a bond to try to go to work so I can keep paying my court costs and keep things going, because I'm doing good. I'm staying on my feet, and I don't miss any court dates. I don't have any failure to appear. I come to court. You won't have no problem with me coming to court. I just want to keep a job and my place to stay. I don't want to have to start all over again. I just want a bond just to get on my feet. I mean, I love my job. And I hate to lose that job because, I mean, I've been looking for jobs for weeks, and I got a job. I just want a chance. That's it. I'm not a threat. I'm not a danger to the community. I'm not going to hurt anybody. I'm not violent. I just want to go to work. I just want to save some money. I want to pay my court costs. I want to do the right thing. I mean,
well, I appreciate that, sir, and I am glad that you have a job you like. I'm going to tell you another concern this court has is you were arrested on August 8th for indecent exposure, and a law enforcement officer, I think, witnessed that action.
yes, and I'm going to come to court for that.
So, okay, hold on. Let me tell you why that's concerning. Because you're a registered sexual predator and that charge is sexual in nature, that concerns this court.
Yes.
All right, let me ask. Sir, I forgot your last name.
Lucas,
Mr. Lucas. I was going to call you Watson, and I knew this was Mr. Watson. Let me ask Mr. Lucas, how long has Mr. Watson lived with you?
about 6 months, I'm thinking.
Yes.
Does anyone else live in the house with you too?
Certainly. I'm trying to think. The landlord is kind of there part-time. He goes to Michigan, then he goes to Florida.
Okay, so it's not your home.
No,
You
it's
also
not my
rent.
home. I rent there.
Is there anyone else who lives there?
Well, right now, like I said, the part-time landlord, there's a guy by the name of Anthony, and just Mr. Watson and myself.
All right, let me look at, I have to look at one other thing. Can the state tell me, was this the original sex offense in 1998?
No, Your Honor. I have a 2017
Oh, I don't know where I was reading that.
5 counts of lewd and lascivious behavior.
In 2017?
2017.
My original charge was in 1997.
I have a.
Okay, that's what I thought. I thought I read that somewhere. Okay, I was right.
Yes, that
I have
was 20 years ago.
It was 20 years ago. Okay. What's in 2017? I'm asking the state about your criminal history, so just give me a minute. You don't have to answer.
Oh, I'm sorry.
It's not for you to answer, it's for her.
2017, I have 5 counts of lewd and lascivious behavior, exhibition of an 18-year-old on a victim less than 16, which are all F2s. He pled no contest to them and got 4 years DOC concurrent. I have a 2015.
4 years would mean he just,
Yes, he just got released.
just got
April
released.
13th of this year.
That was one event, but they charged me 5 times.
He has a 2015 exposure, a 2015 lewd act in the presence of a child and exhibition, which was no prost, a 2013 exposure, so 13, 15, 17, 21.
I was homeless those times. Sorry, but that just makes me look bad.
Ms. May,
Yes, Judge.
can you come look at this? You can come, Mr. Brands, but it's not significant about this case. I just wanted to point it out. That has his age as 24. Okay, just so you know. All right, Mr. Brands, wait, stay. I'm going to talk to the attorneys one more time, please. I'm going to ask Mr. Lucas just a couple more questions, Mr. Brandt, while you talk to Mr. Watson.
Yes, Your Honor.
Mr. Lucas, do you work at the same place Mr. Watson works?
No, I don't.
Do you also work, though?
I work from home.
Oh, so you're there a lot then?
Yeah,
So you're there when he comes and goes?
pretty much.
Were you aware of this August arrest? Did you know he got arrested in August?
I was aware.
Okay. I'm just asking because you seem like a good friend and you seem like you genuinely care about him and want to help.
Absolutely.
That's why I was asking.
Absolutely, I do. He's really, really a good guy.
Your Honor, can Mr. Watson be heard?
Yes. All right, Mr. Watson, one more time, I just want to remind you that everything you say is being recorded and can be used against you later. You understand that?
Yes, ma'am.
All right, go ahead. What do you want to tell me?
I just wanted to tell you, if you gave me the opportunity to bond out, I promise you I would not get arrested for anything. Promise you that. And if I do, you throw the book at me, but I just don't want to, I don't want to lose my opportunity of my job and may a place to stay because I did 4 years in prison. It's going to be very, very, very complicated for me to find another job and to find another place to stay. And I would get out and be homeless again. The more longer I sit in here, I would lose all my things. And I don't have nowhere to put it in storage or anything. And I made some great friends. And I understand y'all concern. I just want to ease y'all concern. I know what my history looks like, but some of those things are just fitting the description. And I took pleas just to go ahead and get it over with because I just wanted to get out. And now it done stacked up against me. And now that I'm trying to get on my feet and do well and do right, I'm just asking for an opportunity. Just give me an opportunity and a chance because I'm doing so good. I'm steady working. I ride my bike to work. I work the majority of the day. And then I be home at night. You won't have to worry about me. I show up for my court dates. I register each vehicle that I'm supposed to register. And for my other situation, I will always come to my court appearance. You don't have to worry about that.
All right, let me ask you a question, Mr. Watson. If I ordered you to keep a curfew, could you do that?
Yes, ma'am. No.
What time do you get off work?
I get off work at 10.
PM?
Yes, ma'am.
Oh. What time do you go to work?
I go to work about 4, sometimes 3. Sometimes I go 12 o'clock and work all the way to 10.
Okay, so you don't work in the morning?
No, ma'am.
Okay, hold on one second.
I will follow that curfew to the finish.
And Mr. Lucas is here, and he wanted to testify to the court because he's your friend. Do you consider Mr. Lucas your friend?
He's a good friend. He's been there for me. I mean, I can't even put it in words and express that. You know, I really appreciate it.
All right, so if I ordered you to maintain a curfew, and I asked Mr. Lucas if he can help you maintain that curfew, are you going to do it?
I promise you. No problem.
Here's the thing. I do believe there's probable cause on that warrant, but I didn't see anything in there that alleged anything like he's ever tried to use the car. And the testimony today is he doesn't, and he hasn't, and he doesn't use it. So here's what I'm going to do. I'm not going to revoke your out on bond and hold you at no bond. I'm going to take no action on that case. But Mr. Watson, I have to tell you, I'm very concerned about that because the allegation in that case is also sexual in nature.
I know you are.
So listen to me very carefully.
Yes, ma'am.
I'm taking a chance on you. Don't make me regret that chance. You understand?
Yes, ma'am. I promise.
All right. Then, in this case, I would normally set that bond at $15,000. I'm going to reduce that. Again, Mr. Watson, I'm taking a chance on you. Don't make me regret it.
I promise you I won't.
All right, I'm going to reduce that bond to $5,000. You must maintain your sexual predator reporting requirements. I'm going to order that you have a curfew. How long does it take you to get home from work?
Takes me like 30 minutes, 35 minutes.
All right, so what I'm going to say is that you have to be in your residence by 10:45 p.m. every night. Do you work every day?
Yes. Except on Monday. Sometimes on Monday I'm off.
I don't know if I can give him 2 different times. On his days off? Are you off on Saturday and Sunday, or do you work?
I work Saturday and Sunday.
So Monday's your only day off?
Monday. Sometimes Thursday. Monday and Thursday, that's usually.
Or sometimes your days off?
Yes.
All right, on your days off, your curfew is 6 p.m. So be in your house by 6 p.m. You understand?
Yes, ma'am.
You can't have any contact with any minor children under the age of 18. You can't drive his vehicle for any reason. You understand? All right, good luck, Mr. Watson. Thank you for coming, Mr. Lucas.
Thank you.
Hope I don't see you again.
Go ahead.
Please tell me your name.
Donna Wendling.
21 CF 12351. You're here charged with possession of methamphetamine. I'm going to appoint an attorney to represent you. There is probable cause in this case. Your bond is $1,000. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand? All right, good luck, ma'am. Anything further from either party before court is adjourned for the day?
No, Your Honor.
No, Your Honor.
All right, thanks, everyone.